argued in front of, I say that with all due respect, bearing in mind that there are cameras here at the moment, and I don't know whether there is a live stream or a live broadcast, I have to raise the possibility that the very argument of the in-camera application would render the application itself and any subsequent determination nugatory because of the consideration of it being in camera. And I must admit, when I read the original directive that said open session at the college, I assumed that that meant we would have an open session in my concern, with all due respect, that the very substance of the application we're going to debate, which will determine how my client gives evidence, is potentially going to be pointless by virtue of the fact that we may have a live proceeding or live television proceeding that goes out. And may I just say this, I can understand that if the Commission is ultimately against me on the in-camera application, that there can be publication of everything ex post facto, because in that instance there would have been a final substantive determination on whether it should be in camera or not be in camera. But if we argue the in camera in open, as we are doing at the moment, and I repeat my concern about live television proceedings, then that creates the prejudice. And you would recall, Chair, that in the notice of motion filed by the applicant, if you have the paginated bundle in front of you, if you look at paginated bundle 3, prayer 2, the prayer 2 notice of motion, with all due respect, I think covers a situation that we find ourselves in, where the very request for that proceeding itself is to be in camera. Otherwise, the outcome would be rendered nugatory. And so those are my submissions as to my preliminary concern. Thank you, Chair.
Thank you, Mr. Premhead. Mr. Premhead, I'm not sure that I follow you with regard to the point that the outcome and what's basically sought will be rendered nugatory. I just don't get that, because what Mr. Karim seeks is that the hearing of his evidence should be in camera.
Yes.
If he succeeds, how will this open session have rendered that nugatory?
Well, that's the exact dilemma, Chair, with all due...
And also, perhaps, let me add this.
Yes.
All, if I'm not mistaken, my colleagues will correct me, and perhaps even the evidence leaders, all applications for in-camera hearings have always been heard here in open session. And a good few of those were found to have substance, and the actual hearing of the testimony was then in camera.
Yes.
So I don't know what makes this one stand out, and for the argument that the whole thing will be rendered negative. I just don't follow it.
I followed the question. If I may respond, Chair. On the first issue about defeat the main hearing, what you will, and now I speak with some hesitation because I'm now traversing potentially some of the merits of the in-camera application, and we're not yet at that stage. We're determining rules of engagement, if I can put it that way. What you will know is one of the arguments that is made in the in-camera is that my client started receiving death threats, and that those death threats emanated even before he gave his actual evidence at the commission itself. And so my client's position is that he is being subjected to those death threats regardless of the actual evidence he is going to give. Now, the fact that we are having this debate about whether he should then still give that evidence in camera or not in camera now reveals to the public at large watching in that he's been the subject of those death threats and that he might be made to give evidence, but it just will happen on a day or in a time or in a format that the public at large might not know about. But the consequence of that doesn't detract from the client on what he says in the affidavits is that he's being surveilled. And the fact now that this has already happened on live television, with all due respect, does not, or rather does, undermine the very purpose of the in-camera, which was to protect that disclosure when he comes back to the commission to give his evidence in chief, if I can call it that. And because of the particular situation that my client finds himself in, the fact that we're already publicizing the fact that he's making the in-camera application is the prejudice that we are talking about. So that's on the first point, if I may, Chair. On the second point, I obviously can't answer for what other applicants did in respect of their in-camera application or whatever the case might be. I'm not privy to that. But on the facts of this case, and because of that surveillance which I've just mentioned, that's why a particular prayer was included in the notice of motion, prayer 2, that the actual argument of the in-camera be held in camera itself. And again, I say this without trying to traverse the merits of the in-camera application, but I'm just registering the difficult position now that my client is in, because the surveillance which happened from the previous session is now going to continue, arguably, from this moment in time, because if my client doesn't appear to the public's knowledge on the 9th and 10th, the public will know that he's compelled to give evidence. It's arguable that the in-camera was granted, and that he's still giving evidence with the effect that the threats are going to materialize again, with all respect, because effectively now has given publication to the very concern that my client had, that he's under surveillance.
So, Mr. Karim, wants the public to be under the impression that he will not be testifying, or what exactly
no,
is the point?
that's
What then is the point?
No,
because if the public or even those threatening him are aware that he will testify at some point, what difference does any of this make?
The difference is, Chairperson, in the two alternative factual scenarios is, let's assume when we came in here this morning, this session was being conducted in camera, in the way that I had understood it would be. What that would mean, with all due respect, is that there would be no insight given to the people outside of this room that the in-camera application was made. And if it was granted, then the public knows that Mr. Karim ought to have testified on the 9th and the 10th. That might not have materialized on the...
Even those threatening him will be under that same
Agreed.
impression.
Agreed.
So what's the
Agreed.
difference?
I was getting to that, if I can finish.
Yes.
What I was saying is that in the scenario that I'm talking about, that if these things were in camera, on the 9th and 10th, if the commission is with me and grants the in-camera substance, then whoever is threatening Mr. Karim and the public at large will have to speculate, why didn't he give the evidence? Is he still giving evidence? Or whatever the case might be, insofar as Mr. Karim's appearance at the commission is concerned. That would not release Mr. Karim from the obligation to still give evidence, which he would give, but it's the details around that evidence and the session itself that would be protected, offer him an extra modicum of protection where he says, I'm being surveilled and I'm threatened even before I give the evidence.
I don't quite see the difference in substance to what I said earlier, which was that, so Mr. Karim doesn't want the public to know that he will testify at one stage or another. The various options or possibilities or permutations you referred to boil down to, or at least part of it boils down to what I said, which is that he does not want the public to know that he will testify.
Yes, but that's not because he has, the case he's pleaded in front of the commission is not because he doesn't want the public to know, it's because of the threats that he's received.
But part of what you said part of what you said says exactly what I say.
No,
Of the various permutations you gave, part of it says exactly what I say.
I accept that, but we
Yes.
also have to accept that there will be parts of your report, for example, that might be subject to certain confidentiality regimes. There might be evidence that is in your final report that is subject to certain confidentiality regimes, which the public at large would not know about. So it's not as though Mr. Karim, with all due respect, is asking for something unique or specific to him that the Commission's rules itself does not contemplate. It's the Commission is being asked to strike the appropriate balancing act between making the witness testify, which Mr. Karim accepts he has to testify, obviously, but at the same time protecting him or offering him a measure of protection that neutralizes or potentially neutralizes some of the threats that he is receiving. With all due respect, I haven't taken an instruction from my attorney at the moment, but just speaking frankly, if this live television camera is on at the moment and it's being broadcast to the public, then actually my application for an in-camera hearing is potentially rendered moot, because the same people who are threatening my client even before he comes and gives the substantive evidence now know what he's attempting to do. And so, with all due respect, I don't even know if there's any point in proceeding with the in-camera application, although my attorney might kick me if I say I'm abandoning it, because of this exact prejudice which has now manifested. I've heard what you've said to me there, but I must obviously put my client's position regarding what is happening at the moment and how that potentially prejudices him in light of the relief that he sought under 4.2 of the Commission's rules.
You earlier said you may already be touching on the merits. Perhaps what I'm going to raise also touches on the merits.
Is this a preliminary concern now, Chair?
No, but no.
Are we still on the preliminary?
I'm still on your preliminary.
Okay.
Preliminary.
Got you,
yes,
Chair. Got you,
yes,
Chair.
Yes. How exactly, everything being conducted in the manner in which Mr. Karim suggests, how will the evidence then be dealt with in practical terms afterwards? For example, you even referred to the final report treating the evidence in a particular manner and perhaps even the public not having access and so on. So I'm raising what I'm raising
Yes.
in the context of
Yes,
that
yes.
submission.
I accept that, yes.
How will the Commission handle the evidence, assuming that the application is granted?
Yes.
Yes. I'm thinking, maybe let me just add, I'm thinking, for example, the evidence may say something about people who may either themselves on their own want to respond, or in respect of whom the evidence leaders may want to lead evidence that counters whatever Mr. Karim may have said. So how does all of this get handled?
I accept.
Because those people will have to know.
No, of course. And
content
I'm
of
not
the
suggesting that a case be conducted against them in their absence or without their fair trial rights being protected. As you know, Chair, my client is particularly keen on his fair trial rights. It would be ironic if he's attempting to... The Minister of Finance is trying to phone me. That must wait until later. I apologize. I'm sorry, Chair, go ahead.
Yeah. Oh, sorry.
Sorry, Chair, what I was going to say to you is that we obviously have no difficulty with whatever accommodation has to be made to facilitate the fair trial rights of any other witness who may be impacted by my client. But what we know, and that's foreshadowed with all due respect in Rules 4.2 and 4.3 of the Commission's rules. But what we know in practice from cases like Bryden and Helen Suzman Foundation in particular, which in your previous capacity, Chair, you would be very well familiar with, there are particular circumstances where the disclosure of evidence in a particular context is subjected to a confidentiality regime that appropriately balances the interests in the evidence coming to the court, or in this case, the
the rules.
Exactly.
What I'm struggling with, or what I don't see,
Yes.
is how that gets to be applied, or how your client relies on that,
Yes.
given what he has
Yes.
set out in the
And
papers.
that's why I started by clarifying, by saying if you want that direct explanation in the affidavit, I have to accept it's not there. But why the Schedule A is attached to the notice of motion is because it's one of the prayers that are sought from the Commission applying the Commission and the chairperson applying his mind. If on the basis of no pleading, the Commission says, well, I can't grant you that relief because you haven't made out a case for that, then I have to accept that. But the reasonable explanation as to why there's an attempt not only to keep this application in camera, but limit who has access to the content of the application is threefold. Number one, Mr. Karim nor his legal team knows the internal processes of the Commission. And it might be the case that not everybody in the Commission needs to be involved in the Mr. Karim specific matters. And so the Commission might in and of itself have its own Chinese walls that it will sometimes enforce or not enforce in order to preserve the integrity of whatever's happening in front of the Commission, which I say applies here in an in-camera request. Number two is that never mind whatever the Commission's own internal processes are, practically speaking, in the light where the case made in front of the Commission is that I'm being surveilled, I am under threat, I don't know who's watching me or who's not watching me. At its most generous interpretation from Mr. Karim's side, obviously there's a less generous interpretation from the case against me, but the most generous interpretation that can be afforded to Mr. Karim is that that Schedule A, which was subject to the control of the chairperson of the Commission at all times, was an attempt to make sure that the net was not cast too widely, so that all and sundry, and I'm using that phrase again, but I'm using it with respect, get access to the very papers that may or may not result in the breach or of Mr. Karim's rights in the way that he's saying in the papers. The third explanation, Commissioner Baloy...
The second explanation, put simply, is he doesn't trust the rest of the staff of the Commission that they may not distribute. Or in fact, he doesn't trust the Commission. He has to leave with a list in Schedule A, but he doesn't trust the beyond that.
I hope that the correspondence bundle has been placed in front of the Commission, because what you will see from the correspondence bundle is that my client has consistently complained about inconsistent treatment, about the Commission's inconsistent application of its own rules, and the prejudice that he has suffered as a result of the Commission's conduct towards him.
Is your answer to my question that, is it a yes? He doesn't trust that the Commission will not share his application outside of the Commission, that with the consequence that those who are threatening him would become aware of it. Is it a yes? To my question?
It is a yes, but
Okay.
I hope you will understand, Commissioner Baloy, that it's not an out-and-out yes in the sense that, my client is complaining about that this is just a farce exercise or that he won't get a fair trial. It's based on his experience at the hands of the Commission that lack of trust arises. And I'm being very guarded in my language in making that point, because that implicates potentially not only my learned friend, the other evidence leaders and the staff of the Commission, of which there are many and they are unknown to me. And I don't want to trample upon the integrity of my colleagues, whom I have known and have no difficulties or issues with. It's just that obviously my client, given the treatment that he has been subjected to, has a legitimate concern which informs the application and the attempt to limit the access as explained in Schedule A.
Just to be clear, that treatment that he's complaining about and on which he suggests he relies for seeking to limit who has access to his papers, does it include a disclosure of whatever he submitted to the Commission to the public?
does it involve breaches of confidentiality? That's the substance.
Well, it's difficult in the facts to answer that in circumstances where we only gave the statement yesterday. No, not yesterday, 2 days ago on the 4th at 9. The statement hasn't become public, which we're grateful for, but you'll remember that the only time we received the direction from the Commission that that statement was going to be kept confidential was when we received the directive, I think it's paragraph 6 or 7, that unequivocally states that whilst the in-camera is being fought over, the main statement will be subject to the in-camera treatment. So obviously, as a result of that directive, that remedies the concern of my client to some extent, as we sit here now, but it certainly animated my client's concerns prior to the handing down of that directive.
I guess what I want to do, Mr. Premier, what I want to get out of you is it has to be clear that whatever your client's complaint is about the treatment he's received from the Commission, it does not include a complaint that the Commission has disclosed what he has to be confidential matter. It has been disclosed to the public. I think it is important for our processes.
Yes.
That is clarified.
That's
not what you're complaining about.
No, that's right. But if you have regard to the correspondence bundle, Commissioner Baloy, you will recall that that around the 28th of February, the Commission started making threats to my client that he was in breach of not filing the statement in terms of the 27th directive. But the Commission conveniently overlooked the fact that the disclosure or the submission of that statement was, in terms of the application that served in front of the Commission, to be pended until the in-camera was decided. And
But Mr. Karim can't make his own rules.
No.
There was, from where the Commission was sitting, there was no change to the directive that he should file his statement.
No, I accept that.
To characterize this as threats
I accept
is
that.
actually totally unacceptable, Mr. Premier.
With all due respect,
Mr. Karim cannot create his own rules. There was a directive that he should file his statement by a stated date. He could not, if there was no change to that direction, of his own motion, choose not to file. Just because he has said, by the way, I am not going to file because pending ABCD is not appropriate for me to file. He could not.
No, absolutely.
If, despite him having said so, the Commission did not change the deadline, it was not for him to choose by when he filed.
But with all due respect, Chair,
yes.
But with all due respect, Chair, on the 18th of February, which is the date that the application was launched, the following was said in that covering letter. And this is why we're having a debate which is slightly removed from the facts, with all due respect. The request was made.
I'm very sorry, I intervened.
Oh, sorry, I apologize. May I
intervened twice. My colleague was still asking you. Yes, please go on.
May I respond to you, and then Commissioner Baloy, subject to the Chair's authority, of course, if you can re-put your question to me, because I'm now dealing with what the Chair says. I apologize for that. But Chair, it's very important, because when the application was launched, what was explicitly raised with the Commission staff and the evidence leaders is a request that this entire application would be disposed of. This very in-camera application that we are asking for today would be disposed of by the 25th of February, which was before the statement was due, so that my client would know what his position was come the 27th regarding the filing of the statement and whether that was going to be in camera and then the hearing was going to be in camera or not in camera, because obviously the determination of the in camera might have also triggered my client's request to file a confidential affidavit with the Commission. And so on the 18th of February, my client doesn't only say, please bring this to the extremely urgent attention of the Chair so that a determination is made by the 25th before our statement is due. He says you can even dispose of this entire matter on the papers. We don't need an oral hearing because this is an extremely urgent matter. The issues are fairly narrow and we want an expeditious outcome so that we know what our client's position is. And with all due respect, what happens on the 18th of February from the Commission, we get a one-line email saying, we confirm that same is in reference to the application, will be relayed to the Secretary and the evidence leader shortly, and we will revert with formal instructions in due course. Nothing is heard from the Commission from the 18th, 19th, 20th, 21st, 22nd, 5 days. And now you must remember, of course, that the statement deadline is coming nearer and nearer. And what we then do on the 23rd is we write to the Commission on the 23rd to say, please can you advise us what the delay is, because our statement deadline is approaching. We might be wrong in the way that the chairperson puts it to me, that it's not for Mr. Karim to determine, but we need some clarity from the Commission, the chair in particular, as to what the next steps are here. And so, with all due respect, Chair, when I talk about these threats emanating, it's not as though my client had, by the time his statement fallen due, not only launched an application where formal relief was sought in respect of the delivery of that statement, correspondence was repeatedly sent to the Commission staff and the attorneys asking that this matter be dealt with extremely urgently and in an expedited fashion. And my client also waived with respect the very right to a hearing that we are having here, because he wanted to know what his position was by the 25th so as to what to do on the 27th. And where I say that those threats from the Commission are unconscionable, and with all due respect I speak subject to the chair putting me back in order if I'm out of order, is that the Commission in its subsequent letters after the 27th don't even engage with the fact that it's due to them that the entire matter hasn't been disposed of on the timetable that might have been extremely urgent for understandable reasons, but where we had asked for a ruling. So why I'm saying that those threats are unreasonable in the circumstances is not because it was Mr. Karim acting of his own accord. Mr. Karim at every stage saying to the Commission, place this in front of the Commissioners, get me a determination by the 25th so I know what to do by the 27th. And when the 27th came and went, we hadn't heard anything. We only received the answering affidavit on the 24th. So, Chair, with all due respect, I hear what you say to me, and I hear your admonition regarding what I said about the Commission's threats. But there's a factual context that's important to bear in mind as well, and that is that Mr. Karim sought the assistance of the Commission to let him know what to do by the 27th.
You say you hear what I say about what you referred to as threats, and yet you proceeded to say what the Commission did is unconscionable. I take strong exception to that kind of language.
I'll withdraw that statement.
Thank you. What you've said raises two issues. What you have submitted raises two issues. The first one is, you asked the Commission to keep all documents, affidavits and all, relating to this matter confidential. The first issue is, I have no idea why Mr. Karim would not have wanted to file his statement if, in the face of his request, and there being no basis for him to believe that the statement would not be kept confidential. That's the first problem I have. And then secondly, my point about there having been no change with regard to the deadline, yes, I've heard what you say, but the bottom line is the deadline was never changed. The deadline stood. So on those 2 points, I still have difficulties with your submissions.
Chair, I don't know if you want me to respond. Or
yes, you are free to.
Concluding
yes.
Remarks?
No. You are free to respond.
No, thank you, Chair. I appreciate that. Yes. On the first issue about not be kept confidential, I'm not going to rehearse what I said. All I'm going to point out, Chair, is the first time that was given unequivocally, that the main statement would not be disclosed prior to the determination of the in-camera, was only finally clarified on the 3rd when the directive came out. That was on the facts after the statement.
Just on that, why right from the beginning, instead of tying the filing of that statement to the hearing of the interlocutory application, why did the applicant in the first place not make the simple request that that statement should be kept confidential.
But with all due respect, we did, and that's addressed, that's in the founding affidavit and the notice of motion, and it's in the covering letter. And that's part of the difficulty we have here, is that we place all of this in front of the Commission, we ask for an expedited decision and an outcome, and instead of being told or being told by the Commission, yes, your concern about the main statement is taken care of, it will be held in confidentiality until such time that the in-camera is determined, we don't hear anything. The first time that the Commission puts up an answer is on the 24th, and incidentally, it doesn't deal with the request regarding the in-camera. If the Commission was able to give that undertaking by the 24th when it filed the answering affidavit, then we wouldn't be having this debate, because by the 27th my client would have filed the statement.
All 15 pages of it, yes.
Yes, absolutely. Whether it's 15 pages, 3 pages,
I know,
100 pages.
I'm just, yeah.
Whatever the case might be, he would have been able to file because the undertaking would have been given. The only time that my client then was given the assurance is when the third comes down, the third directive comes down, and look at what happens. When the directive comes on the 3rd, and the directive says, you must file your statement by the 4th, and you must file it by 9 o'clock, and it will be kept confidential, the statement is filed, no difficulty. So with all due respect, it's a bit unfortunate that my client finds himself in this position in circumstances where he's not in control of these things, and a concern is raised for determination that affects the filing of the statement but is being dealt with in the way that I've just explained. So that's on the first issue regarding the main statement. The second issue, Chair, which I've now forgotten because I've written a note here that says deadline, but I have no idea what that means.
I think I've forgotten also, but probably...
As long as you forgot, Chair, that's fine. That's okay for me.
Probably it was that, but the bottom line is that the deadline was never changed.
Yes.
Whatever may have been going on in Mr. Karim's mind, the bottom line is that the deadline was never changed.
But that's it. But you see, that's, with all due respect, it's that catch-22 dilemma that my client is caught in.
Do you know what judges usually say? They say that when counsel says, with all due respect, deep down inside they're saying, what the hell?
Chair, I've never been accused of using such soft language in my entire life, so I'll take that. I'll take that.
Mr. Karim, you wanted me to reformulate my question, to re-put it to you. I thought you had answered my question, but then you went on to muddy it with the threats and the filing of the statement, and all of that was said about it. But I had, the first part of your response was, you are not saying that there's been a disclosure of information submitted to the Commission by Mr. Karim, which he had marked to be confidential. You are not saying the Commission has landed that kind of material in the public domain.
Yes, we're not saying that.
Yeah, that's what I wanted to clarify with you. And then my next question, which I may well now ask, it's now out through you, right, in the engagement with the chair, why you want this application to be in camera. We've had many slip-ups like that from legal representatives, where they do seek something and then they are the ones that actually disclose that which they're asking for.
Yep.
Or that they're arguing. So it's now in the public domain, the reason that you want this application to be in camera. Is there still hasn't the issue become moot? At least this first part. Hasn't the issue become moot, and we should just go ahead and hear that part of the application?
Chair, my attorney is whispering something to him. Chair, through you, may I just take the instruction? Thank you. Thank you. Commissioner Baloy, before I forget your second question again, I'll still go back to the chair, but in response to you, Commissioner Baloy, yes. That's exactly why when I started, I said I have to place my concern on record that if we have this debate in the manner that it's happening, the very purpose of the in-camera would be rendered futile. And so when I started my remarks, that's why I needed to record that, because I was caught in a catch-22. Either I sit here silently and look at the three of you, and the three of you look at me, and I don't say anything, or I have to address what I need to address, but my claim for confidentiality and in camera is then materially prejudiced by that. And it's that very conduct, with due respect, that I'm saying has caused the prejudice that my client complains about in the affidavit itself. I mean, it's that famous Sutherland judgment, BDFM versus SAA, that once confidentiality is lost, it's difficult to get it back. And that's the exact position my client finds himself in. So I accept that it might have been through my own doing, but it was under the cover of recording the concern I had regarding the futility of us proceeding then in the way that we had.
I guess it may become necessary for us to, for completeness, to pronounce on your argument for confidentiality. It may well be, without changing anything, because as you seem to agree, you know, the issue has become moot. We might as well go ahead with this application, but then the chair may have to pronounce on this claim for confidentiality, whether there was a case for it in the first place.
Yes, may I say, Commissioner Baloy, it's like one of those interlocutory disputes that arise in a main proceeding where the determination of the interlocutory then has the unforeseen consequences that it has. And given that as we walked in, we were then subject to live television cameras, that's the catch-22 that I was caught in, but also that my client was caught in. So even though the application is theoretically still in front of you, because as the chair reminds me, we're still only dealing with the preliminary point, I accept the consequences of the arguments that we've just had and we've just made. May I just go back, Chair, the second point that you had made, which we had both conveniently forgotten, but then unfortunately you remembered, about the deadline. I hear everything that the Chair says. I would only ask that the Chair bear in mind that there was a request for a ruling before that deadline came and went, so that my client would know what to do in circumstances where he says, I'm asserting a right of confidentiality. If I give my statement, that will render my asserted right of confidentiality nugatory. And on the other hand, if I don't give the Commission what they want, I am then liable to coercive force by the Commission in the enforcement of its rules. So yes, the deadline is what it was, but it's not without the prior context of, please tell me what to do before that deadline comes so I know what my position is. Thank you, Chair. May I just check if there's... Oh, I apologize, Commissioner Kumalo.
Permit, you could have just said, here is my statement, it's ready, please treat it confidentially. There was no need for all that drama. You wanted to consult with your attorney and then we will ask our questions after, so... Yeah.
Thank you very much, Commissioner Kumalo, for the indulgence.
I don't want us to debate the point I made, because I think the preliminary point has become, I think you should just leave that prayer. Prayer 2 must just be abandoned. And when you deal with prayer 3 and 4, I will tell you what my concern is.
Before the merits, may I? Did I get the impression that, but for our engagement, you were done with your submissions, Mr. Premier?
On the preliminary, yes, I think it's only fair that Ms. Hassan
Yeah,
gets an opportunity
that's where I want to go to.
respond.
That's
Absolutely.
where I want to go to.
Although I
Are
don't
you
think-
accepting your abandoning too, so that we don't need to debate?
I would prefer the Commission make a ruling against me rather than abandoning it.
Okay.
All right.
Thank you, Chair.
Ms. Hassim?
Thank you, Chair. I mean, in the light of the questions that came from the Commission, I can be brief just on the preliminary point. I think we should probably just get straight to the merits because, as Commissioner Baloy says, this issue of the preliminary point has become academic. After the first, I think it was only after the first minute or two of my learned friend's address, we strayed right into the merits. And so part of what's been debated in fact, concerns the merits of the application. But even though, that should be the end of it, I would like to say one or two other things. The first is that my learned friend says that he did not understand the session today to be a session in which it would be a public one. And I must say that's hard to understand in the light of the directive of this court on the 3rd of March.
Commission.
Pardon me, of the Commission. I must wear my other hat. In the light of the directive of this Commission on the 3rd of March, which stipulated that it would be heard in open session. Now, even if that were not a live broadcast, what it could not be understood as is to be a session that would be closed to the public. So even if it were not a television broadcast or live streaming on other platforms, this was going to be an open session, open to the public and open to the media. So any reporting or any coverage, photographs, anything would still be permitted in an open session. So it doesn't aid my learned friend to say that, understanding of what an open session was that it would be somehow closed and that it would only be perhaps the legal representatives and the commissioners. On the statement, let me say, the statement, it's always been the practice of the Commission, and there's never been a breach of confidentiality thus far, not in relation to this witness or in relation to any other witness on the side of the Commission staff or evidence leaders. So that is not something that ought to have given rise to some suspicion.
But on that, I can imagine that Mr. Premid will probably say neither he, his instructing attorney, nor Mr. Karim knew that procedure.
That was, and let me say that there has been some clarification in that regard, that statements that are given, the practice is witnesses provide statements to the Commission before they appear before the Commission to provide their oral evidence. It's only once the witness testifies that the statement becomes public. So it would only be on the determination of this application, which would then determine what kind of procedure follows next, that the statement would become public. That's the second thing. The third thing I want to say is that in relation to the perceived threats of the breach of the ruling of this Commission, it is important that witnesses understand, and the legal representatives, what the requirements are of the Commission and the status of rulings that are given by the Commission. So it wasn't in the nature of a threat. It was in order to advise the witness that you now are in breach of the ruling of the Commission, and it's important, and a duty, I would add, of the evidence leaders to protect the processes and the integrity of the processes of the Commission. So a ruling that says that the statement is to be provided on a certain date is that. It cannot be amended without the Chair's reconsideration of the ruling, which would require an application, and there was none such application in that regard. And finally, on the statement, it really wasn't tied to the determination, it wasn't conditional on the outcome of the in-camera application, right? Because the statement is for the purposes of providing evidence to the Commission. So I just wanted to make those remarks with regard to the statement to clarify that. But I've also said what I've had to say about the ruling on the 3rd of March, that this was to be an open session. For me, that's where this preliminary debate would end. And so, and then given that the ship has sailed, we should probably proceed into the merits of the application. Thank you, Chair.
Thank you, Ms. Hassim. Mr. Premhead, one last. Yes. Any response, Mr. Prem?
Yes, three very brief ones, if I may. In respect of the first point made by my learned friend about her understanding of the directive, with all due respect, it's not her understanding that matters. It's what the Commission makes of the application and the request for the ruling beforehand. And that's why the ruling was made beforehand. The request for the ruling was made beforehand, so my client wouldn't find himself in the exact position he finds himself in at the moment. On the second point, my learned friend, in fact, actually makes the case for us because her exact words were, it's the determination of this application that would thereafter determine the disclosure of the main statement. And that's exactly why, not only in the correspondence and in the notice of motion, but in the founding affidavit, before that statement was due, the direct application was made at paginated page 12 of the pleadings bundle, paragraph 27, I humbly request that the Commission determine this matter as one of urgency. This is because my witness statement is due on Friday, the 27th of February, 2026. If a determination is not made about my hearing evidence in camera, and with that regarding the witness statement, by this date, then my witness statement will be made available to the general public, defeating the purpose of this application. If that was wrong, they filed the answering affidavit on the 24th of February. They could have made the undertaking or given the clarity on the 24th of February that the statement wouldn't be disclosed.
But why would he have thought, and I think that's a point that Ms. Hassim was making, that his statement would be made public before he testified? On what basis does he have that concern to a point where he doesn't abide or comply with a clear directive?
But that's because, as the chairperson foreshadowed, is that my client doesn't have knowledge of the inner workings of the Commission.
It's not about the inner workings. It's about what, you see, what he has done, and I have to deal with this by way of an example. He has made a claim. He's making a claim for confidentiality and for in camera, based on the threats he has received, but matters that he says are reported in the public domain. He's made references and he's annexed stuff that is in the media. So he's relied on matter that is in the public domain. I'm asking a question like that there is nothing, he knows nothing about the processes of the Commission, as you rightly say. He doesn't know our internal workings, but again, he has nothing from the public space that is a basis for that concern about his statement being made available to the public. He makes it up. He makes it up, and on the basis of that fear that he's making up, he then says, I'm not going to file my statement until you give a ruling because it might go into the public, when there's absolutely no basis whatsoever, no factual basis for him to raise that kind of concern, and therefore not to abide a ruling that says you must file by a certain date. So it's not an answer to say, I guess what I'm doing is I'm saying, how reasonable is this fear about my statement will be disclosed to the public when there's absolutely no factual basis for it?
I accept that, and you've already heard me in my opening remarks that, to the extent that explanation is needed in the affidavit directly, it's not there, and I'm not going to push at that. Instead, what I will say, at the risk of repetition, is that that's the very reason why the ruling was asked for by the 25th, so that he wouldn't be in the position of potential non-compliance, because that clarity, and on the basis that Commissioner Baloy has accepted, he wouldn't know the internal working processes, would be given to him. And so when I was reading from the founding affidavit, and I mentioned the answering affidavit that came on the 24th, that was the day before the ruling was originally sought. And if the Commission, in its answering affidavit, simply said, we'll give you the confidentiality pending the determination of the in-camera, then that would have cleared the path to file on the 27th. And so those are the facts about what came before the Commission, and we can't, with all due respect in assessing reasonableness, determine the unreasonable. Thing, Commissioner Baloy, and then I must make my third concluding remark in response to my learned friend, Ms. Hassam. On my client doesn't rely on threats in the public domain. My client relies, and that's what I understood Commissioner Baloy to have said about things in the public domain. If I misunderstood that.
Yeah, no, you misunderstood
okay.
me. Yes, I wasn't saying he relies on threats in the public, made to him in the public domain.
Then,
I was saying there is nothing in the public domain that finds
the breach.
Founds,
yes,
yeah, absolutely.
Yes.
That's
now,
the point.
Then we're ad idem. Then I don't have to say anything further. I understand what you were saying, Commissioner Baloy. Thank you. And then, lastly, in respect of the issue of the threats, I think it's also just important to say it out loud and on the record that 2 witnesses that have come before this Commission have been killed. One allegedly killed themselves by means of suicide, but did so after there was an attempt on their lives, and the other was apparently killed potentially or allegedly in relation to what they may not, or may not have done here. And all I would say in conclusion, in reminding the Commission of that, is that your job and mandate is about serious issues that go to the heart of the criminal justice system and potential abuse of political connections, criminal connections, and political power, which threatens a huge many deal of interests of people. And where witnesses are dying after coming to the Commission and giving evidence, it's surely not unreasonable in those circumstances that my client uses whatever procedural remedies are available to him to try and get relief from this Commission to protect him in some way to make sure he's not subject to the same kind of treatment which is evidenced in his founding affidavit. Thank you, Chair.
Mr. Premid, I don't want to leave it uncorrected that the person who committed suicide testified before this Commission. That person was never a witness before this Commission.
I apologize.
So I don't want it to be left that way in the public.
I apologize.
Because factually,
I spoke correct. Then subject to being told the incorrect thing. I apologize then. And I withdraw that to the extent I need to.
That actually deals with part of my preliminary point.
Ms. Premid, you're going to go into the merits, and maybe just you'll deal with this in the merits. I don't want you to deal with it now, so I can either, in advance of you arguing it, just tell you what my concern is, and then you will deal with it when you argue, and then we can raise questions as you go along. If you look at prayer 3 and 4 of your notice of motion, read with your Schedule A, the effect of it is that the Commission's investigation team must not have access to these documents. The Commission's head of security must not hear this evidence, must not have access to these documents. Now, that is problematic because that is the work of the Commission. There is no way you can have a prayer. And our researchers, there's no way you can have a prayer that says the very evidence that's going to be led, your investigator must not hear or know about it. Because their job is to investigate everything that is presented and provide the Commission with facts. So, the prayers are problematic, and I will just give you an example with prayer 3. We have, for example, a Mr. Brown Mokgotsi still coming to finish his evidence. If your client, either in his statement or in his evidence, says something that implicates Mr. Mokgotsi, or that Mr. Mokgotsi would like to respond to, Mr. Mokgotsi and his representatives must have access to that in the same way that your client had access to the evidence of Mr. Mokgotsi. And you would have said it's prejudicial to your client if they were not given the evidence and the statement. So it has to work both ways. If your client mentions any person and gives evidence against them, they would be entitled to that. So you cannot have a situation where all papers exchanged in relation to your client's evidence are not disclosed. It cannot just be this open-ended. And then you've had me on the commission staff, especially, on matters of security, for example. The commission's head of security, and I won't go into detail because those are sensitive matters.
And internal processes which we're not aware of, absolutely.
To assess what security arrangements
Sure.
have to be made, he needs to have access to all of this. So you cannot say he must not have access, because how else does he do his job? Do you follow me?
Yeah, no, I do.
Yeah.
Chair,
I'm sorry. Commissioner Kumalo said that that's for when you address the merits, and that think about it and deal with it when you address the merits. I think we've reached. You were to?
That's why I was looking to you to give me direction whether it's now time to address the merits or not.
No. Let's adjourn for 5 or so minutes, give or take. We'll indicate when we are ready. So we are not strictly saying 5 minutes. It may be more. Let's adjourn.
Thank you.
please switch off your cell phone.
My direction is to refuse that the application, main application, be heard in camera. That's my order. So it will be, the merits of that application will be heard here in open session. Reasons will be given on Monday. Brief written reasons. Let us take the tea adjournment. We'll resume at 11:05. Let's adjourn.
Chair?
let's lay down some ground rules. We afford each side 30 minutes only to argue, uninterrupted. We will ask our questions, if any, right at the end. 30 minutes, that's very fair. I'm not even asking you whether it's fair or not. I know it's very fair. So now, I see Mr. Premier is smiling, so I'm sure he's happy. Now to my preliminary issue before Mr. Premier's argument starts. I want to raise concerns about some of Mr. Karim's language in his affidavits. We do have thick skins, but if we must call something to order, I think we should. Subject to cogent explanations being given, I find some of the language gratuitous and at times both gratuitous and sensationalist. Let us look at paragraph 9.1 of the supplementary affidavit at page 54. There, Mr. Karim says, I'm reading the last 4 lines, part of the 4th, paragraph 9.1, I said yes. And quote, it would be concerning in the extreme if it were willing, that is the commission, to gamble with my life or my family's life to see whether the commission's, underline this, kill rate would result in a, again, underline, hat trick, close quote. I read this to mean that the commission has killed, underline the commission, has killed 2 people, and that Mr. Karim will be the 3rd person it kills if the commission does not grant his application. That is how I read what I've just quoted. Now, Mr. Premier, what evidence does Mr. Karim have that the commission has killed 2 people?
Chair, may I say that I hear what the commission says, and that's not how, with all due respect, I interpret that sentence, because before Chair started reading from, it would be concerning in the extreme. The sentence from about 5 lines from the bottom starts with, the commission has already experienced 2 such incidences. So with all due respect, when it's spoken about the commissions, and I say 2 such incidences, taking the correction that Commissioner Kumalo has made already, I'm just reading out what's there. So how I read it is not that the commission killed anybody, but that the commission has experienced, in Mr. Karim's version, subject to the correction, that 2 witnesses that came before it were killed, and that he's saying that the commission's kill rate, in the sense of the number of witnesses that they've experienced having been killed, would result in a hat trick, and that he doesn't want to wait and see that happening. But that said, I take the admonition in the way that it is presented, and all I can do is apologize to the commission if that indeed caused the offences both being gratuitous and sensationalist.
Thank you for the withdrawal and also the apology. Right at the end, in my notes on engaging with you, I was actually going to call for an apology for this. But let me conclude the debate on this aspect, subject to whatever response you may have, by saying that, yes, earlier, as you indicate, there is reference to incidents. But commission's kill rate, that cannot mean anything other than that is the rate at which the commission is killing. The commission's kill rate. You cannot, I just do not see how one can seek to change that. And that kill rate, or the rate at which the commission is killing, is going to result in a hat trick. That is Mr. Karim being the third person the commission kills. That is my reading of this, and I found it quite offensive, but you've apologized. It is the commission's kill rate. It's nobody else's kill rate. It is the commission's kill rate.
Chair, without repeating myself on the apology and the withdrawal, I would just say that I respectfully disagree with you, because I think that's a very narrow reading of that phrase in isolation, not only from the rest of the sentence, but also the founding affidavit. So if the commission can look at paginated page 11 of that same bundle, please, in the founding affidavit at paragraph 18, at the top of the page, I'm reading...
Page 11.
Paginated page 11, yes please, Chair, 1-1. On my side, it's paragraph 18 at the top in the founding affidavit. I don't know if it's the same on the commission side. I'm getting indications it is. He explains what he talks about, where he says one of the witnesses that appeared before the commission was killed, and there was an attempted assassination on another witness who shortly took his own life. And he goes on to say, I am compelled to take these threats seriously. With all due respect, even if the commission and if the chair interprets that phrase to mean what the chair says it does, why I disagree is because at no stage has Mr. Karim ever used words to that effect, to say it's the commission who's doing the killing. It's the commission's kill rate in the way in which the chair is putting it to me, as opposed to what we are saying, or what rather the witness is saying, regarding the experiences of what has happened. But I understand that the chair has a different interpretation.
I just don't see how paragraph 18 assists you, because it just refers to killings. Those may well be the killings of the commission, hence the commission's kill rate. But anyway, so I don't see how paragraph 18 assists you at all.
Well,
perhaps we should not waste any.
No, I was going to say, I think that's where we part company, Chair. Yes, but I must reiterate for the record both my apology and the withdrawal there.
Thank you.
On that interpretation that is put to me.
Thank you. Then let's go to the answering affidavit at page 45. Paragraph reply, I'm very sorry. Yes, the replying affidavit. Paragraph 66, it reads, instead it is clear that the commission or only Mr. Popkas has opposed the application for an ulterior purpose and out of vindictiveness. I assume that the reference to an ulterior purpose is what, inferential reasoning perhaps? I assume so.
Well, I'm in front of you, so I will bear responsibility for this replying affidavit, and I'll answer you.
Actually, before you apologize and review, one of the things I had noted down here with regard to what we've dealt with already was who settled this affidavit. Was it you, the attorneys? Obviously, it could not have been Mr. Premhead himself, but I think you basically want to suggest that you settled it or not.
No,
Yes.
I am, regardless of who settled it.
But we are past that. You've retracted, you've apologized.
No, it's more than that. It's more than that, and this is important for the public watching to understand. Is regardless of who said what and who settled what, I am the advocate in front of you, I am the appointed leader, and I take full responsibility for anything that causes the commission offense or upset. And as I've said, I apologized and withdrew in respect of the 9.1, I think it was. If that's what the commission wants of me in respect of 6.6, I will do the same thing. All I would point out is in that paragraph, the second sentence tries to lay out a justification for that particular reason. It cites paragraph 5.1 of the commission's answering affidavit. Now, I accept in 6.6, there's not an detailed exposition to justify the first sentence, but at the very least, the deponent is telling you what they are identifying as the basis for the first sentence. But again, I think with all due respect, I'm not going to defend the so-called indefensible. I will take responsibility for it, and I apologize to the Commission and the commissioners, and I withdraw as is needed.
All right, thank you. Perhaps let's leave it there. And why I introduced this by saying, is this reasoning by inference? I was then going to take you to what the test for inferential reasoning is, and then I would have also asked you, has that been satisfied for Mr. Karim to say that this is being done or averred for ulterior purposes?
Yes.
But perhaps let's leave it where. Yes.
May I just say on that particular averment in the paragraph, insofar as the determination of the issues in front of you is concerned, that is actually not a central issue. To the extent that it's been called out and
I would have thought so
yes,
too.
Exactly.
So that too, in a sense, is quite gratuitous.
No.
Thank you.
But that's why I'm accepting your logic, and I'm
yes.
saying to you, I fully accept what you say to me, and I give the tenders as needed.
Thank you. Let's go to your 30 minutes then.
Yes.
What's the time now?
I'm familiar with that 30-minute of grace before the barrage of questioning starts. So is Mr. Khumalo. He argued a few days before me when I was there for Phala Phala. But, Chair, may I say this? I think that
I'll give you until 13 minutes to 12. You may start.
Chair, I was going to say that in light of what has occurred for most of the morning, we had prepared a note on argument which I was going to have regard to, but I think that has largely been overtaken. Instead, I intended to structure my submissions to you in the following ways, if I may. I'm going to deal with 4 topics very briefly. Firstly, is I'm going to address why we're here. Secondly, I'm going to address the questions put to me by Commissioner Khumalo. Thirdly, I'm going to refer you to some cases on what I think are trite propositions in scenarios like this. Lastly, I'm just going to make some comments about prejudice. So, at the outset, and we've already debated 4.2 and 4.3 in the morning, the simple proposition is this: it's not the evidence itself, and Commissioner Baloy actually identified that there's a distinguishing feature about this application and how it was brought and when it was brought in respect of other applications, and I adopt that analysis because that's the very point that I want to start with. It's that it's not the actual evidence that my client gives which brings us here, but rather the fact that merely by appearing here on the 6th of February as a confirmed witness who was then granted a postponement and which gave rise to the 4 or 5 threats that we've attached to the 2 affidavits, which don't only threaten my client individually, but also threaten his family, that threaten the burning down of his businesses, that threaten them if they even leave where they were originally located. It wouldn't matter because where they would potentially be moving to would also be known. And I'm trying to use language so as to not give away geolocations. Those are the serious threats that bring us here. So the reason for the in-camera then is, and I say this with all due respect, the reason for the in-camera is the threat to the life of the witness, his family, his businesses, and his economic interests. And that is not contingent on our reading of the rules of the actual evidence to be given in chief by that witness themselves, because nothing in the rules makes the application for an in-camera hearing contingent on that evidence in and of itself. I'm willing to accept for the sake of debate that it might be a factor that the Commission takes into consideration in deciding whether or not there should be an in-camera hearing or there shouldn't be an in-camera hearing. But what I will say in that regard is that that factor is but one factor in the basket of factors. And what else is in those basket of factors, in other words, in addition to the evidence that he's going to give, is the existence of those threats, the way in which he has treated it seriously, and reported it to the police because of the seriousness involved. And I must say this, the Commission, in response via the answering affidavit, starts out the answering affidavit with saying, I have some sympathy for Mr. Karim, but, and then goes on to say why the in-camera should be refused. And with all due respect, those reasons as to why it should be refused are reasons that we in fact rely upon in order to justify the in-camera. So those reasons that are relied upon by the Commission are inter alia the following. The first thing the Commission says is that the applicant has already been the subject of national media coverage, that his identity, appearance, and scheduled testimony are already in the public domain, and therefore the consequence of that public knowledge is that, well, an in-camera hearing is going to be pointless because everybody knows. But the truth of the matter is that if the in-camera relief is granted, then everybody will not know. Yes, they would have known what the arrangement was for Mr. Karim to give testimony in an open session was, but they won't know what actually occurred thereafter if he doesn't give testimony in the way, in an alternative way, if the in-camera application is granted. So, with all due respect, the Commission's position that this has already been in the public eye is the very reason that we come to the Commission, because you will know we say that these threats have started emerging even before he's given the evidence. So it means that the people who are threatening my client don't know what he's going to say. But they are so aggrieved potentially by whatever it is he's going to say, that they're already making the initiative to threaten him, his family, his businesses, and his employees, as well as his economic interests in the way that it does. The second thing that the Commission says is that, and it's a line of argument that is rooted in open justice principles, and indeed in the morning, I think it was potentially the Chair and Commissioner Baloy who put it to me when they said, I thought, or used words to the effect that I thought he would want to come and give this evidence in open so that everybody knows what's going on. But with all due respect, that argument again makes the case that we are applying for, and that is that this publicity, without the threateners even knowing what it is he has to say, are already threatening him. If he comes here, it's almost like waving, and that is not made subject to an in-camera ruling, it would almost be like waving a red flag at a bull and waiting to see whether or not the bull charges and gores you, and effectively to take your life into your own hands. And the reason I say that, and mindful of what the Chair has already said regarding those particular paragraphs, fictitious, these are non-credible, are made up. They seem to accept, at least at the surface level, that these threats are real. And so the question then becomes for the Commission, bearing in mind, and the Commission and the Commissioners, bearing in mind that you have an applicant in front of you who says, I am scared, I am fearful. Does the Commission and the Commissioners turn a blind eye to that in circumstances where no one has suggested that those threats aren't real, aren't credible, aren't serious, and don't deserve to be taken as seriously? So that's point number one about why we're here. We're here because of the fact of the threat, and any opposition mounted on the content of the main witness statement, I would submit, is firstly misplaced, but secondly, to the extent it's not misplaced, it's but one factor in the basket of factors under your consideration. The second topic I want to talk to is the question put to me by Commissioner Khumalo. Commissioner Khumalo, you took me to the Schedule A, and you had indicated that the schedule was problematic because it excluded certain people and, was perhaps too restrictive in terms of the people that it did include. And you mentioned particular individuals like the head of the security, the investigation team, the researchers, and all these categories of people. I'm willing to accept that this might be too constrained, and the reason I can readily accept that is because we simply don't know who the relevant people are in the operation of the Commission behind the scenes. Likewise, for example, in trying to get the application in front of you, we don't know how long it took when the Commission's received it to put it in front of the commissioners, whether it was placed in front of you before the 25th of February, whether the correspondence bundle, like we asked to be placed in front of you, was placed in front of you. We don't know all of these things. And the reason I highlight that...
They're in the website, Mr. Freeman.
I beg your pardon?
They are in the Commission's website.
Please continue, Mr. President.
Be that as it may, it can be on the Commission's website, it can be stapled outside the Commission's premises. The point of the matter that I'm making, Commissioner Khumalo, is that parties often ask courts for relief all the time based on what they understand the position to be. Sometimes a court will say to them, as you will well know, yes, you've made out a case, but this operative part of your relief is a bit too narrow or a bit too broad, and we need to include these people and we don't need to include those people, or whatever the case is. So, with all due respect, if it's a question of the schedule, we can amend the schedule. Or if it's a question of the Commission making a directive regarding who should be included and who shouldn't be included if the Commission is with me, then that satisfies the issue with all due respect. Because like I said in the debate in the morning, and I think it was with the chair, is that these requests have always been subject to the chair making the appropriate ruling, either accepting and granting the application or dismissing the application, or granting it but subjecting it to different grounds on the relief, or anything of that kind. So I think with all due respect, it's a little bit difficult for me to answer the way in which the question was put at me in circumstances where it's being positioned potentially that Mr. Karim is dictating these things. It's Mr. Karim saying to the Commission, I'm asking you for these things based on what I know at the time that I know it, and I lay myself in the Commission's hands as to make the ultimate determination. So if the accuracy of the schedule is incorrect, we wear that. And we wear that not because we want to keep some people out or some people, we simply don't know. And that's why we come to the Commission and ask for the relief that we do. May I go on to my third topic? And I think, Chair, I'll be done with my protected time relatively soon. May I just take an instruction? Yes, and I'm just being pointed out that the particular paragraphs that Commissioner Khumalo had difficulty with was 3 and 4. I think what I've just addressed is the difficulty with paragraph 4. Regarding the difficulty with paragraph 3, I just would point out that it's not the main statement that was subject to the in-camera, it's the in connection therewith defined as being in the in-camera application. And I mean, even if the drafting is not clear enough to make that clear, let me make this clear now on the record. That must obviously be the case, because if the in-camera application that we're arguing now is unsuccessful, then the normal rules apply. But if the in-camera application that we are arguing now is successful, that would be subject to whatever the Commission and the Chair ultimately grants as the relief. And again, I understand that the concern against me might be what it is. I don't think that the idea has ever been that the main statement must be kept away from the relevant Commission staff. It must be kept away from it being an open publication, or as effective as an open publication, content in camera. And in regard to the Brown-Mokhotsi example that Commissioner Khumalo raised, apart from saying that I don't know whether Mr. Mokhotsi applied for an in-camera hearing or an in-camera hearing and how that would impact fair trial rights, like I said in the morning, part of the Commission's imposition of an in-camera regime would make accommodations, as it must, for these kinds of issues to be ironed out. So that, like we know, for example, in high court proceedings and in all court proceedings, where there is a confidential affidavit filed, sometimes what the court says is it seals that part of the record, and the parties are given a full opportunity to engage each other on the contents of that confidential affidavit. It's just that those exchanges of affidavits are subject to a confidentiality regime. And we don't ask for anything more than that. And in fact, we ask the Commission, if such an in-camera regime is going to be upheld in these circumstances, that that's the kind of consideration that is applied. May I say then, on the third topic that I had, which was about the cases that I wanted to deal with, I think these are fairly trite propositions that I'm making from the cases that I've cited. I've given my learned friend notice of those cases and the paragraphs that I'm going to rely on. So I'm not going to ambush her very deliberately. But my learned friend raises her eyebrows at me. But these cases, we say, put forward two propositions. The one proposition is that the state has a positive duty towards citizens to protect them where there is a concern about their rights. That is derived from cases like Carmichael, Carmichael, I apologize, I always say Carmichael, Carmichael, at paragraphs 44 and 45, and the court will be familiar with Carmichael. And then the other case that we rely upon is the SCA case of Van Devenboden, which the commissioners will also be familiar with, and the paragraphs there are 20, 21, and 22. Now, why that's relevant, of course, is because we say that on the facts of this case, there is a threat to the right to life, security, integrity, family, commercial interests of the witness. This is a body that exercises public power in the name of the state, and so this commission is caught by the same obligations that the state has to make sure that where issues of safety are raised, that it properly applies its mind and discharges its power in accordance with that. The other two cases, sorry, I said 4 cases, there's 6 in total, and I'll come to the other 2 shortly. The other 2 cases that I want to refer to is the Constitutional Court matter of independent newspapers, otherwise I think commonly referred to as Masetla, at least that's how I know it. And the paragraphs there, the relevant paragraphs there are 42, 43, 44, 45, 58, 59, 60, and 61. And the other case that I would refer to whilst I'm talking about Masetla is the SABC versus NDPP case that came before the Con Court. And I think that was, I speak subject to correction, but I think that might have been in the context of Van Breda and whether or not his criminal trial could be subject to publication. And the paragraph we rely on there are 28, 29, 30, and 31. And what those cases make abundantly clear is that courts in those contexts, we say courts, it applies as equally as against this inquiry as a tribunal, must engage in a balancing exercise where default positions of openness, which is what the default rules of this commission envisage, conflict with competing and contesting rights. And where those competing and contesting rights are put before the court, and this relates to what I was saying earlier about one factor in the basket of factors, the court will seriously apply its mind to circumstances where it treats openness by default not as an absolute principle, that there are justifiable circumstances where it will derogate from openness as the default principle, and that those require then the application of this balancing act, and we say that some of those factors that need to be included in the balancing act are those cases, are the instances where my client comes to the commission and under oath tells you about the threats that he's facing to life, limb, property, and family. The other two cases, if I may, whilst I'm machining through this list, is MIDI Television. I apologize. I think MIDI Television was Van Breda. I said SABC versus NDPP was about Van Breda. But MIDI Television, which the tribunal will be familiar with at paragraphs 19, 20, and 21, and the other older constitutional court case of Mamabolo, which, if I'm not mistaken, was written by Justice Crickler, and the relevant paragraphs that we rely on there are 41, 42, and 43. And what we say those two cases give rise to, again in the context of discussing the openness by default principle, is that firstly, no single interest, this is from Mamabolo, no single interest overrides others. So yes, just because this commission might have an interest in an open justice style of argument, that justice will be seen to be done, does not mean that that is judged in isolation from competing interests where security of the person is concerned and so on. The second proposition that these cases give rise to, which is from the MIDI Television case, is that the restrictions on publication are permissible where it's demonstrable that there is substantial risk to justice or to other constitutional interests. And we say that we fall into that category. We fall into the category that there is substantial risk to constitutional interests, and that's why the in-camera application, in the way that it is brought before you, is entirely justified. Chair, on the last topic, if I may, the topic of prejudice, I did address some of this prejudice in the morning at the so-called prejudice being at the hands of the Commission, and I'm not going to repeat myself there. Instead, all I'm going to say, Chair, and you will recognize this not only from having deposed to the answering affidavit in the unsuccessful urgent application, but also when we were in front of you in the postponement application, that my client's complaint throughout his involvement in this Commission's proceedings is one about consistency, fairness, and procedural and substantive rights. Rightfully or wrongfully, that's his view, that he is being treated in a way that is prejudicial by the Commission, and in fact, what is happening is rather than the Commission seeking to cooperate with him and his reasonable requests, like, for example, receiving the proper 10-6 notice, like, for example, receiving the bundle in good time, like, for example, receiving an undertaking regarding the confidentiality of the statement in good time, like, for example, that an expedited application which is sought to be determined before a deadline is approaching is placed before the Commission, doesn't seem to happen. Those are the head notes, if I can use that phrase, of what my client claims as his ongoing prejudice in these proceedings. And I mention that prejudice because it's regrettable that we find ourselves in this position. Unfortunately, the way in which my client seems to be treated is in an adversarial manner rather than what we understand a role of a commission of inquiry to be, as being an inquisitorial manner. And unfortunately, the way in which things have unfolded in front of this commission have meant that, I apologize, someone is trying to phone me again. The difficulty that my client has is that rather than reasonably being accommodated so that he can come to the commission and give the evidence and do his inverted commas job and get out of the commission as soon as that job is done. Instead, we get tied up in these kinds of procedural skirmishes where, at the end of the day, like, for example, on the issue of the bundle, which was the subject of the postponement application, the bundle eventually was given. A specific bundle was eventually given the night before we were expected to appear for the first time. And why I highlight that prejudice in the context of this ongoing dispute we have in front of you is that in the absence of any credible basis to say that these threats are not real and not serious, we would say, and I say this in a guarded manner, that it's heavy-handed of the Commission, with all due respect, to oppose the application on the basis that, it's already been publicized or whatever else it is they say. Because at the end of the day, if the in-camera application is granted, this Commission will still be able to do its job. And it's important to say that because the in-camera application at various times is treated as though it's an act of gamesmanship, which it isn't. It's a legitimate request under the Commission's rules for protection from the Commission regarding the giving of that evidence so that my client can do what my client needs to do because this Commission has asked him to do it. All we would say is that when this Commission brings my client in front of it to give such evidence, that it does so in a manner that is suitably sensitive to the threats that he faces and gives appropriate relief to protect him in light of those threats. Might I take an instruction? Just whilst, before I yield the floor, so to speak, just one thing that we are aware of. Obviously, whilst we sit here, we expect the Commission's supplementary bundle, which we anticipate to be given today, because it's 2 business days after the filing of the statement. We hope that that will be done, because that will again help my client come and do his job, rather than end up in another procedural skirmish about whether or not there's been adequate time or inadequate time. But Chair, those are my remarks in my protected time, and I yield. Thank you.
Thank you, Mr. Premhid. Just on the last point, Ms. Hassim, I assume that if that bundle is not ready, you will move mountains for it to be served today.
The bundle will be provided today.
Thank you. Thank you. Mr. Premhid, you, quite early on, you made maybe let me start right at the end. I'm not sure that I follow your submission on the relevance of what you refer to as head notes on prejudice to the determination of the in-camera application. I'm not sure what the relevance of those head notes is exactly. You did explain it, but I still remain in the dark as to what you suggest the relevance is.
May I respond? Thank you, Chair. No, I accept what you say to me. What I am using those particular examples of is, in each instance of those examples, my client has asked for a reasonable accommodation, which has been refused. The response to that has then been that my client has to, through its legal representatives, litigate quite aggressively, whether in court or in front of the Commission, with interlocutory applications, to have that reasonable request, firstly, reasonably considered and then decided. And I was linking that pattern of conduct to the opposition that is being put up here, and I explicitly detailed those grounds of opposition, the publicity, the fact that it's already known, but importantly, there's no counter-argument as to the credibility of the threats, that in those circumstances, the Commission insisting that my client be made to give the evidence in an open session where those threats are highlighted for determination is a further instance of the prejudice that my client finds himself in. That's the extent I was using it.
I trust, though, that the suggestion is not that the in-camera application will not be decided on its merits.
No, not at all. I know for a fact it will be decided on its merits.
I just wanted to be sure in my mind what exactly you mean by that.
In fact, Chair, if I may, I think the way you've put it to me crystallizes the exact point. It's that in each of those instances that I've spoken about, my client, to use your phrase, has had to move mountains to try and clarify his position and get certainty and outcome. And this in-camera application is yet another example of that, in circumstances where my client not only said on the 18th, a week before, he asked for an outcome by the 25th, bearing in mind that the 27th was the due date. He also said, just determine this on the papers expeditiously, so we don't have to take up the Commission's time and I know what I need to do. So I fully agree with you, Chair. It must be decided on the merits, but the fact that we've had to repeatedly move mountains to get that determination, and even in circumstances when we ask for an earlier ruling, is the exact prejudice that my client relies upon. Thank you, Chair. I'm indebted.
Thank you. Now, let me take you to something you said quite early on, which is, and I hope I will not mischaracterize what you said. You said that applications for in-camera hearings, or rather this application for an in-camera hearing does not hinge on the evidence Mr. Karim is going to give. Even though I cannot think of ready examples, I'm willing to accept that that may be so in some applications. But what exactly do you say is the basis for your submission in this particular application? I'm asking that in this context. Not every and any witness that has testified before us has received threats. And those that have either received threats or had a reasonable basis to believe that their lives were at risk, even if they had not received threats, gave us cogent reasons for us to understand why there would have been threats and why there would have been a reasonable belief that there was a risk of bodily harm or even a risk of them being killed. Something cogent was placed before us. Please bear in mind that here I'm not talking about just the fact of threats. I'm talking about what underlies the threats that we are told about. That's where my focus is. Now, on what basis would Mr. Karim, I know the threats don't come from him, and he says in so many words in his affidavit that he does not know where the threats come from. But if he sits down and applies his mind in the light of the testimony that he's going to give, who does he think may possibly be threatening him? He is best placed to think about that and possibly to even come up with answers to that. Bear in mind that I say in all without exception, all the other cases where applications for in-camera hearings have been made, we were given something cogent, which had a factual foundation.
Thank you, Chair. May I respond? Chair, on the first point, where you said, you put to me the not hinged proposition, and you said it may be so, just to emphasize that our position is that based on the Commission's rules, that doesn't seem to be the case to us. But let's leave what the rules may say or not say to one side for the moment. The not hinged proposition comes from the fact, like I just read back to you in Mamabolo, it's a weighing up exercise. And so
I'm not there yet. I am not at Mama Bulo in that weighing up exercise, because you raised the weighing up exercise in the context of open justice. So I'm not there yet. I'm just at the level of possible facts, the possible basis for threats.
I'll come to that last.
That's where I am.
I'll come to that
I don't
last.
quite see how the Mama Bulo balancing exercise, the open justice principle,
Yes.
I just don't see
May I
how
develop the submission?
how the relevance of that is to what I'm raising.
May I develop the submission?
Yes,
And I will come
yes,
to those very
yes.
point about the facts that you put to me. I'm sorry if I'm taking the circuitous route. The reason that I start at Mama Bolo is because it speaks to the court's discretion in weighing up issues in front of it when there is a counter consideration to the default position of open justice. So, insofar as where I anchor my submission, that it's not exclusively contingent on the content of the main witness statement, is derived from the Mama Bolo principle, buttressed by the MIDI television principle that talks about we derogate or we depart from open justice when there are credible threats and so on. So I'm willing to accept.
I'm exactly at the credible threats.
Yes, I'm coming.
I think that's where we should
Yes.
be before we get to the balancing exercise. Show me the. I'm just asking you a question, and I'm not suggesting that the threats are not credible.
And I'm not
All I'm
suggesting
saying
that either.
is, what is the possible grounding? And that will then help us
Sure.
determine the question of the credibility
No.
of the existence of the threats.
I-
That's where I am.
I accept that.
Yes,
I accept
yes,
that.
yes.
But I think what's important is where I started out, because that sets the ground rules with respect as to what discretion the court is being asked, or I apologize, I keep saying court. I look at you, ADCJ Madlanga, and I go back to a different time and different place. But, Chair, it's about what discretion this inquiry tribunal is being asked to exercise. And that's why I start with both Mama Bolo and MIDI television, because it says that yes, you consider openness, but you consider all the things on the other side of the T account, if I can use that phrase. Then let's go to the examples that you gave me. This is now the facts and the credibility that you were talking about. Those examples, from my understanding of what you have said, Chair, is that they were all anticipatory explanations for why in-camera hearings should be justified, because if I get your words wrong, Chair, please correct me, but you said something to the effect that those witnesses who asked for in-camera hearings gave cogent reasons for us to understand who would have threatened them or where those threats could have come from, in anticipation of asking for in-camera.
Or even where they would come from. In
yes.
regard to those witnesses
Yes.
who did not say that there had in fact been threats.
No, so you and I are ad idem on that. And I would say that my client is, with all due respect, in a stronger position than those people. Because what my client says, or does, is he doesn't come to the commission on the basis of reasonable speculation about what threats I might face or where those threats may come from or who may be giving those threats. My client, by contrast, comes to the commission with real threats annexed to the affidavits and says, look at what I'm being subjected to. Now, yes, it might be that my client is being criticized for not doing a further exercise in the way the other witnesses did, in answering the 5 W's and the H, where did it come from, when, who, and all those kinds of things. But look at what my client does. Apart from coming to this commission to ask for the in-camera relief, he goes to the police and says, investigate this, and he lays a criminal complaint on the basis that he has received these threats. So, again, going back to the Mama Bolo MIDI television framework I was talking about, it might be that the failure to address those questions weighs as a factor in the basket of factors against granting the in-camera application. But I would say, with all due respect, imposing that on my client and doing so in an adverse way in the balancing exercise is contradicted by the factual position that he's in.
I'm still not at the balancing exercise. I'm still at the level of the facts and what would, where, put it this way, who would these threats possibly come from? And I repeat that I'm saying, Mr. Karim is best placed to scratch his head and come up with ideas as to who these threats might might come from. And I'm raising this because this is going on the 9th and 10th. This is going to be his testimony and his alone. He knows what he is going to say, against whom, and who therefore might possibly want to threaten him not to say whatever it is he might be minded to say. It's on that basis that I'm raising this.
No,
let me just, I'm not saying I do not believe him. It's very difficult to say that I do not believe him when there is no affidavit that says, Mr. Karim, you are lying. But sitting here, looking at what he says, I want it to make sense to me. And I'm saying part of what would make it make sense to me is possibly who he thinks might threaten him. Do you understand where I'm coming from?
We are at Eden.
And this has nothing to do with the balancing exercise. I'm purely at the factual level.
I mean, I think it does come to the balancing exercise, which is why I started there. However, I understand what you're putting to me, Chair. What you're saying is the sufficiency of explanation regarding the possible source of those threats is missing from the affidavit. And to the extent that that is missing from the affidavit, that may be something which, if you had, would have made your decision maybe easier, but now that you don't have it, makes it a complication for you in terms of how you apply your mind to the relief sought and the outcome. I understand us as being engaging on that sufficiency explanation, not whether the threats are credible or not credible. Am I?
I know you are good at reading gestures. You do that at the Constitutional Court all the time, and even address the gestures in your argument. I'm not sure that I want to get there. That is, get there to the extent of saying, I'm 100% saying there's no issue with the credibility. I'm not there yet. I'm actually testing the credibility in wanting to find out who could possibly have threatened Mr. I'm quite mindful that we are dealing with an application that's on affidavit. And, I don't even think we get to plus and evens here because there's nothing countering or seeking to counter. I realize all of that, but it does not mean that we cannot engage at the level of, is this something credible just on its face? That's where I am. And as part of that engagement, I want to know who Mr. Karim thinks may possibly be threatening him.
Well, I can't give evidence from the bar, and I'm not going to give a version on behalf of my client, whatever he might have told me in consultation. I don't know what you're showing me. In consultation. So I now, in front of you, I can't give you that explanation. What I can accept is that explanation in the way that the chair is putting it to me is something that should have been there or might have been preferable if it was there, and I accept that it's not there. And what I am saying to you, Chair, is that even in the absence of those particular averments being made, that does not on its own undermine the credibility of the threats as they are evidenced on the papers, and as you yourself, Chair, have said to me, no one says in response to those threats, explained as they may be, Mr. Karim, you are a liar, Mr. Karim, these are invented, Mr. Karim, you're just wasting our time because this is a gimmick from you. So what I'm saying is I'm confronted with the position where the chair says to me, these questions might have been, or these issues, if they were addressed, might have been preferable. They're not addressed in the papers. And I'm saying in that circumstance, it is what it is, and that we can still seek the relief. But I don't know, and I'm speaking without an instruction, but I don't know if these are the inquiries that the Commission is interested in, which again, without rehearsing anything about prejudice, if we weren't treated adversarially, and if we were treated perhaps a bit more reasonably, we could have been advised about or told about. Because remember, we're also making the application on the strength of the Commission's rules, where these kinds of issues, yes, they might be raised by the chair, they might be relevant, but they're not specified in the rules. So my client is again caught between a rock and a hard place, where he looks at the rule, he does what he thinks the rule says.
On that point about if perhaps an indication had been given, would a supplementary affidavit assist?
I was just going to come to that, and I was going to say that's what I was going to say without an instruction.
Yes, Mr. Premhid.
I was going to say, Chair, that that's what I was going to come to regarding a without instructions submission, was that given that position and where we are, a supplementary affidavit dealing with these issues pertinently may be relevant for the Chair and the panel to consider. But of course, that might have consequences in terms of my learned friend, and obviously mindful of your judicial role, you will say to me, but now you're supplementing after you file the application and you're trying to remedy after the fact. I'm just tendering this as a practical or potential practical solution to the position we find ourselves in, which is if those are the kinds of questions that the commissioners are interested in, then my client should probably file a supplementary affidavit addressing those questions.
The fact that I raised it does not necessarily mean that that will be granted.
No,
it's
absolutely.
something that will be considered. Yeah.
Absolutely. But that's why I say you might punish me for not having that there at the beginning. So I'm expecting it on both grounds.
I don't think we would be that strict. There's a whole lot of things that apply in court that do not apply here. For example,
I agree, Chair.
The nature of the evidence that we may admit here.
Absolutely,
All right, let me go on. You see, my difficulty, and which is why I'm engaging you on this, is this. The threats from where I'm sitting appear to come out, like a bolt of lightning, as it were. No factual foundation whatsoever. They just proof. But there are threats,
yes,
and there's no explanation on their possible source.
Yes,
we've engaged on that.
Yes,
but I'm just explaining why I'm engaging you to the extent I'm engaging.
Yes,
that's just to explain. And they seem to just come out of the air, as it were.
But Chair, that's the exact dilemma my client faces. That these threats do come out of the air. And that they're coming from numbers, and he says under oath.
And something I forgot on the last point I made. There are witnesses who before us were under circumstances that are not comparable at all to Mr. Karim's situation. Not comparable because they were in far more serious situations in terms of the testimony that they were to give and ultimately gave, possibly expose them to the risk of bodily harm and even death, by far. So on the face of it, simply no comparison from where I'm sitting with Mr. Karim's situation, which makes it difficult from where I'm sitting to understand where on earth these threats could possibly have come from. About 2 weeks or so, we had an IPID investigator who testified openly here. I know that the facts of one case cannot necessarily be used to determine another, but I'm just showing you this to try to make you understand why I have difficulties with threats that appear to come from nowhere in the sense of a proper grounding. That's where I am. That witness testified here, and she told us in graphic terms the risk that she was and continues to be exposed to. And she was brave enough to sit there and testify openly before us. So, as I say, I know at the to understand who possibly, who is, at least at face value, unless there's some explanation, does not appear to be in a risky situation at all. The risk that we see comes from the unexplained threats. Any response to that?
Yes, thank you, Chair. May I just say that had my client, and I need to speak very carefully because there are things that have been said to me which are not in front of the Commission, and so, but we're coming pretty close to discussing that, so I just need to give that caveat, if I may. Had my client known, or reasonably known or suspected, one would have imagined him to say these things. And he not only says to you about the unknown numbers and doesn't give an explanation who those potentially might be under oath to the Commission, he gives an equivalent statement to the criminal case where he's opened a criminal complaint and said, this is all the information I have, here's the threats, please investigate because it's threatening me. Now, I don't want to be impertinent, but the police are hopefully not going to turn around to my client and say, no, sorry. We're not going to investigate these threats despite the objective evidence of these threats because you didn't do your own forensic exercise as to who it may be or what.
I don't think the two are comparable. And,
No, but
please, yes. Okay, let me not gag you.
The point I'm making is that even an imperfect complaint to the police can sustain investigation. Obviously, we are in a different here, but the point is it's the fact of those threats in the criminal scenario that would trigger a criminal investigation. It's the same facts and of the existence of those threats that are placed before the Commission by the witness who gives the fullest explanation. And the Alice in Wonderland world we're potentially heading towards is that my client will be refused relief on an insufficiency ground potentially, but the same insufficient evidence in front of the criminal or the police might result in an actual criminal investigation. So, my is that through the enforcement it's an exercise that he was supposed to do that is now coming back potentially if he knew who these people were, he'd say it. Like the Commissioner is putting, those would be weighty factors as to whether or not to grant the application. But then how do you expect the witness to engage the hypothetical counterfactual? It could be circumstances one back to you, they tell you saying that the Commission is expecting my client to go down the world of speculation, but what must my client speculate about where he says, I don't know numbers, I don't know where their connection is, and must he invent a potential connection between, and I ask that rhetorically, of course, I'm not saying he must invent, I know that the Commission is not saying that, but I'm putting the proposition, must he invent that connection in order to get relief in front of the Commission? So that's the danger with where we're going down with respect regarding the sufficiency explanation. May I just make two points in response to what the Chair has just put at me, and then I will yield again. That's why, with all due respect, what other witnesses did or didn't do, and whether they were brave enough to sit in an open session or not brave enough to sit in an open position, is actually immaterial. And it's immaterial because I don't understand the position to be that you need to show a quantifiable level of harm to try and trigger this kind of relief from the Commission. It's rather whether if we use interdict language, for example, there's a reasonable apprehension of that kind of harm. And in these circumstances, on the facts, what we can't run away from, even with the evidence being as insufficient as it might be, is that the existence of those threats are on the table in front of you, and that grounds the reasonable apprehension. Given that those, I fully accept what the Chair says to me, but that's really the difficulty that I'm in, and which is why I will gently mention the supplementary affidavit again, if it should help.
One last point from me. I hope I'm not articulating this out of context. You said something like, the people threatening Mr. Karim do not know what he is going to say. Wasn't that part of the submissions you made? I do not follow the basis of this submission. Is it not more likely that people that would threaten Mr. Karim would be people who have somewhat of an idea of what he may say, and therefore would threaten him exactly because of their belief as to what he may say? So I don't quite follow your submission.
Yes, what I was pointing out was just the factual timetable in which it arose. So it's obvious, well, let me not say. We assume that Mr. Karim is not just going to be subjected to threats by anybody, right? We can assume for the sake of our engagement that Mr. Karim is going to be subjected to threats by people who potentially know what they think Mr. Karim is going to say or not say, and how that might implicate or impact them. All I was saying in respect of what you put to me, Chair, is that before he then even comes and says whatever he might say, he's the subject of the threat. So why I mention that is because it demonstrates, with all due respect, that whoever these people are, and whoever they may be, and whatever the connection they have to Mr. Karim, direct or indirect as it is, are taking this kind of hostile attitude towards him, this kind of threatening posture towards him, which is a generic threat that's not premised on what you're going to say. It's your participation in the Commission at all is going to result in us coming after you in the way that we're threatening you to do so. So all I'm saying is that let's imagine a world where Mr. Karim comes in front of you and there's someone out there who thinks that he's going to say something about him. But then he comes in front of you, doesn't say anything about them, right? That person then they don't know what he's going to say, but he might be the one who's threatening him even before he says it, before he comes here. So that's the dilemma that my client is faced in, and that's why, Chair, I can adopt what you say to me regarding who these people potentially are, but I'm just emphasizing that the way in which these threats come about in terms of the timing shows how serious they are, that they're making these threats even before he comes here and says anything. So I understand what you say. It's just that I have a slightly different view on that exact same proposition.
Thank you, Mr. Premier.
Thank you, Chair.
Thank you, Chair. Thank you. Mr. Premier, I think the first two things that your client relies on in an affidavit, need to be straightened out. You have withdrawn your chances to the death by suicide of Mr. Pretorius. On that anymore. Am I correct to understand
that's the consequence of being corrected and me accepting the correction.
That's not one of the facts he relies on. The second is the killing of Mr. van der Merwe, witness D, that he relies on in his affidavit. And he annexes, if you want me to refer you to remind you.
Yes, please, Commissioner Baloyi.
If you look at the main affidavit, and you go to page 15 of that, it's yes, 15 in the main affidavit, but it is it's obviously mentioned in the affidavit itself, and then he annexes this, and this is one of the factors that he raises with us as part of his concerns that he may be killed. Can we just perhaps clarify with you that there is no evidence or information in the public domain or before this commission that supports a statement that the witness was killed because he testified here? There's no such evidence. This is still very much a matter of police investigation. Okay, you're not stating it as a fact.
Yes, and I would do no more than look at the headline of page 15, where it says, in an apparent hit of the witness.
Yes.
So my client's position has been that these things are happening.
What things are happening?
Well, the apparent hit is happening, and that he relies on that article to say so. He's not attaching evidence that has come in front of you. Or
he's not saying he was killed because he testified.
Yes.
That's not what you're trying to say.
The position taken by my client is that, and I'll direct you, if I may, Commissioner Baloyi, back to that paragraph 18, which didn't help me earlier, but I'm hoping is going to help me now, is where he's giving an explanation of what he understands to be happening regarding witnesses. And he's contextualizing that to say, I'm just not willing to take a risk.
Yes.
He's not being definitive. He can't be definitive.
In paragraph 10, he says, it is well established that there has been assassinations and attempted assassinations of witnesses who have appeared before the commission or who are scheduled to appear before the commission to testify. Right? And then he attaches those articles.
That we just spoke about,
what I'm putting to you is he makes that statement, but in fact, as a matter of fact, there is nothing that says the witness died because he testified.
Yes, I have no difficulty in accepting that. I have no difficulty in accepting that.
All right. Now, having done that, can we, and in light of your discussion with the chairperson, can we have a look at the documents that you've attached as a threats?
Yes.
Because I would like to, firstly, maybe let me foreground it this way. Your client is a businessman, right? That's what he tells us in his affidavit.
Yes.
He's a businessman. Your client tells us in his affidavit, at least in the annexures that we have here, he's a member of the ANC.
Yes.
Okay, so
that's not in doubt.
We've got those facts, right? Now, I look and please assist me to the extent that I may be misreading these annexures. Now, my reading of these annexures, except the last one that we will get to, none of these annexures, the first is at page 14.
I'm there.
There is absolutely no reference to his appearance before the commission.
Yes.
Previous appearance and anticipated appearance, right? Nothing about it makes that connection. Do you accept that?
Subject to the caveat that factually, yes, I accept it, but my submission in respect of this annexure is that the timing of it is suspicious, alternatively convenient, given when it comes. So factually, does it mention the commission? No, it doesn't. But in context, the submission is that it's related, inextricably related, to his appearance here and the evidence here.
When he first appeared.
Yes, yes, that's right.
And this would have been, he would have received it, if he did, he would have received it after the court application.
No, because if you look at the page 14, it says
doesn't have a
Sunday.
date, yes.
And I think the Sunday that's referring to is Sunday the 8th of February.
And the application was issued when?
The application was
High
heard
Court.
that Tuesday, I think that was the 3rd, and then we were in front of you and the order came out on the 5th, and then we were in front of you on the 6th.
Okay. So the application was in the preceding week before he appeared before us.
It was in the same week. It was heard and determined in the same week.
The chronology I'm trying to clarify is an application was issued.
Yes.
The agent application was issued.
Yes.
And you were heard
Yes.
before he came before us.
Yes, 3 days before.
Okay. And so this is issued only after he's appeared before us.
Yes.
And in the court application, he does mention that he's going to be appearing before us, but he doesn't get a threat. In the period between the court application and his appearance before us, there's no threat received.
No, there are none.
Okay. So we've cleared that page 14 doesn't make any reference to his appearance before us, right?
But may I say something
Yes, you
in
may.
response to that? Isn't that ironic? Because when he is in the urgent application, and the possible outcome of the urgent application is maybe he doesn't have to testify, given what the skirmish was at that moment in time, there is no issue. There is no threat issued. But just thinking about what the commissioner has put to me in the timeline, after he comes here on the 6th, and one of the outcomes from the 6th is the chair's order directing you will appear on 9th and 10th, not even 2 days later than on the Sunday, the threat is issued.
Yes.
And the threat is then about whatever is happening here, about your life and your house. And even though it doesn't mention the commission, I would just point to the timing, using the exact facts that you have put to me, Commissioner Baloy, is, as I said, either ironic or convenient.
Well, yeah, maybe it is convenient. I think the point that I'm making to you is, well, the first time anyone knows that your client is coming to the commission is not when he appears here. That's a point simple point I'm making. That the first time it is public knowledge that your client is going to appear before the commission is with a court application. That's the simple point I'm making.
Yes.
That's the simple point I'm making. As a matter of fact.
Yes.
Yes. That's all I wanted you to accept.
I can give that fact because
Okay.
those are the facts. I can give
Okay.
the answer. What I'm trying to resist is the path we seem to be going down regarding the timing of the threat vis-a-vis the appearance here in front of the commission and the absence of a threat vis-a-vis the application and the inference to be drawn
No,
potentially.
I'm not at inference
Okay.
stage
Well,
yet.
then I have no concern.
I'm not there yet.
Then I have
I'm
no
at,
concern.
I'm at fact establishing stage.
Before we go there, potentially, yes.
Potentially. So we've established page 14 does not make any reference whatsoever. So,
Yes.
this threat could, on this page alone, the source, the reason for the threat
Yeah.
could be anything. Could be his membership of the ANC,
Yes.
could be his business associations, in any of that,
Yes.
maybe even the commission.
Yes.
But we have no basis
No,
on
but-
page 14 to link it to the commission.
Yes, well, no explicit basis to do so, but...
No basis at all. What I'm suggesting is there's no basis at all.
No, that's where I need to resist that conclusion with all due respect, because
Yes.
by the same token that you put up two other possible explanations, his membership of the ANC and or his business interest, why is the commission and the timing of the commission seemingly discarded, but
No,
two
I've
alternatives
included the commission. I've said to you, it may be the
Yeah, okay.
commission.
Well, then-
but I have no basis
Yeah.
to say it's one or the other.
So-
there are three possible bases from what I've put
Yeah.
to you, I've proposed to you. There are three possible bases.
or more. We
for
don't know.
Absolutely.
Yeah, then
Yes.
we're ad idem. Thank you.
And then A2 we've agreed it says nothing about, it doesn't help anything, right?
That was the
Because-
attempted assassination.
Yeah, no, this is the death, in fact, of witness D, him being shot.
The one at page 15.
15, yes.
Yes, yes, the apparent hit. Sorry.
Okay, so this has nothing to do with being a reason, providing a reason for your client to fear appearing before us.
Well, you've heard me on that already, and I've tried to read that in context for you, having regard to the other paragraphs in the affidavit where he gives an explanation regarding how he sees these things happening, which animate his fears. So, factually, I accept your correction of the record like I did earlier with Commissioner Khumalo,
Yes.
but with all due respect, I don't think that that detracts from the underlying point, which is that even if he's misunderstood the correct facts regarding what happened in respect of this witness, that is nonetheless something that animates the fear, which triggers the in-camera. That takes us to a reasonableness assessment. But
Yes.
so I
Of
think
of
we're
course,
at Eden.
it's up to us to look at these that he's referring to, finally determine whether that fear is reasonable or not.
Yes.
So it's not for him to say
Yes,
of this, then we must make a decision that favors him. We have to assess the reasonableness of his fear, and we can only assess it on the basis of what he's really on. Right?
yes,
Order-
I
order
accept that.
96. Okay.
May I just say that, and I speak subject to correction, but the answering affidavit doesn't make these points about what could have animated my client's fears and says, oh, well, you know, you talked about two witnesses, but actually this is the correct factual position. And so in as much as obviously the Commission needs to correct the record where there are mistakes and apply its mind to the issues as they are, the point that I would make is that the Commission fails to correct that animation regarding the fear.
Yeah,
So-
but what are you saying? Okay, now that you're saying this, what are you saying we should do with that? Just because the Commission doesn't deal with it in the way that you say they haven't, are you
Yeah.
saying it's not within our powers to determine on the basis of what he has placed before us? Because maybe let me suggest this to you. As I see it, is even if they had chosen, the evidence leaders had chosen not to answer, we still have to determine your application on the basis of the case you made.
Absolutely.
Yes.
But
so it's irrelevant. It must be
Well-
relevant for purpose of my engagement with you. It's relevant for purpose of you replying to Ms. Hassim, but for purpose of my engagement with you, it's irrelevant that they didn't say what you're raising now. What's relevant is your answer to what I'm raising with you.
Yes, and may I just say that I have no difficulty regarding the proposition you put to me regarding what you need to do. Absolutely, I'm not disagreeing with that. All I'm highlighting is that even his mistaken approach regarding what animates his fear is not rebutted by the Commission as a mistaken basis to animate the fear.
Okay.
So,
Mr. Premier, we have a few times said the evidence leaders are wrong in what they have said. So it doesn't take the matter any further for you to say, well, they are not saying it. As I say, you'll reply to her if she tries to make that point.
But I'm sorry, I think we're speaking slightly past each other, Commissioner,
Yes.
with all due respect. I'm not taking a pleading point in the sense that, oh, the answering affidavit doesn't put up a rebutting version, therefore on Plascon Evans. As the chair rightfully said, there are rules that apply in a court proceeding which do not apply in these proceedings.
Yes.
All I am saying, insofar as your assessment of reasonableness is concerned and what animates the fear, is that even if he was mistaken at the outset when the application was launched, the Commission, who is in possession of the true facts and the full facts in a way that we are not necessarily in possession of, could have said under oath, here's some facts that you need to think about regarding animating your fear. And I'm not making the pleading point. What I'm saying is that I have reasonably or not reasonably adjusted my client's position regarding the in-camera. And so all I'm saying is that where the Commission itself doesn't put up a version to disabuse
But,
my
but
client.
what version could they possibly put up, Mr. Prime Minister?
Exactly the version you put to me now,
I'm
Commissioner
not putting you.
Baloy.
No, what version have I put to you?
You put to me, sorry, maybe I shouldn't call it version, maybe I should say you put two facts to me. It's even stronger than a version. One was about the witness D or F or X.
Mr.
or-
Pretorius, that he died of suicide.
Yes,
He
and
was
then-
not a
and then
witness
there was-
before us.
And then there was the other.
And you're saying the commission should have said that in their answering affidavit?
Well, if they did say that in the answering affidavit, that would have given us a base, that would have given us basis for pause. And it would
But-
have invited my client to respond to that and maybe then explain why he's nonetheless afraid to
No.
come and give open evidence.
No.
Or evidence in an open
When,
session.
when your client or when a deponent makes allegation in an affidavit and they say these are factual allegations on which I rely, such as Mr. Pretorius, he died, he was a witness and he came to testify and subsequently he was killed. Where does he get it from? It's for him to justify that
But-
statement. It didn't have to take, there's no requirement that the opponent should have said, but that's not what happened, so that he can formulate his next response or next position. Your client asserts, the deponent asserts as a fact, and the chair sought to engage you.
Yes.
Where do these facts
Yes.
the stuff that is alleging,
Yes.
where does he get it from?
Yes.
It's not open to you, at least from where I sit.
Mm-hmm.
It's not open to you to say, well, the evidence leaders should have told us that he was never a witness, when it is your client who says he was a witness and he was killed because he was a witness.
Yes, I think where there's a potential, where we're potentially speaking past each other, is that I accept what you say regarding the affidavit, the contents, the accuracy, and whatever the case may be. All I'm saying is that in response to that and putting the facts to me in the way that you have should nonetheless not result in my not enjoying a consideration of all the other factors that he puts up.
Oh, and that's if that's what you're saying,
Yes,
you
that-
don't even need to say
Yes,
it,
well,
of
well,
course.
well-
His application will be considered
No,
on his
then
merit.
we're ad idem.
Okay. All right. Let me continue the exercise that I was doing with you. The next annexure is A3. A3 is a continuation of that witness D, Mr. van der Merwe's killing.
Are you at page
and-
20?
Yeah.
Oh, sorry, 22. I see 22.
22, it's at 22. I just
Yes.
want confirmation. It's a continuation, right?
Yes, it's another
Of that-
article
of
regarding,
that same story that we have now discussed.
Yeah.
Okay. And then the next one is at page 24. Okay.
I apologize. Yes, Commissioner?
All right. It's at page 24.
I'm with you.
All right. It starts off with tell your every driver at. Okay. And then it says tell your every driver at that fire started. And we will that everywhere where there is that company, we take them out. So the reference is there. Which and you can correct me, which on the face of it seems to be threats related to his business or emanating in respect of his business. And the next one says, before you appear, the commission will show you and your boy go to the commission behind your the threat relates to the business affairs. It mentions business.
All due respect, you know what I suppose document those the business and is even if we assume I assume in your construction of the message that the first two messages are aimed at businesses, what does it matter in circumstances where the subsequent two messages, which don't mention the business's shore, are saying, go to Madlanga and see what happens to you?
Yeah.
So I don't know whether, and
So they will go to Madlanga and we will show you and your ice boy. So the ice boy surely has nothing to do with coming to the commission, because we are not calling anyone that's referred to as ice boy.
well, that depends on, that depends whether someone you have called is or isn't an ice boy, depending on what your final report says. I mean, I don't know. I'm not going to speculate, but I think with all due respect, this is the difficulty I'm having with the interpretive exercise, is that we're picking out parts of the message.
No, I'm not.
and-
I'm actually saying in context.
Yes.
I'll do exactly what you say.
then
we
I
are
apologize.
required
It
to
might be
do,
me who's
and I'm
picking
saying
apart.
in context, I'm unable to say in context where his business is mentioned, somebody else is mentioned, and it says go to the commission and we'll take care of you. Why we will stay behind and take care of you while you're at the commission. In the context of all those messages, it's not clear that in fact, this is do not go to the commission. That's we will punish.
We will show you and your ice boy. So they're saying, actually, we're not going to wait for you to donor and skit after you go to beforehand. And then go to Madlanga, we will stay behind and take care of your stuff. So we're threatening you before you go there, and then when you go there, we're going to do more to you.
All right.
So with all as to the construction of the context, I think, and I say this respectfully, a little bit artificial to identify those two messages, take them out and say they have nothing to do with the commission, but then ignore potentially the most direct threats which follow immediately thereafter, and I would say respectfully, give context to what those two other messages are about. The targeting of the business
Yes.
is that might be how the threat manifests, is that we might necessarily going to come and shoot you, but we're going to go to your offices and shoot your employees or burn your offices down.
Okay.
That's the context that we're talking about, and that's you.
Right. I do need to move it along. Then let's go to the page 6. And why do you say that has to do with the commission? We've got people who say, I can't quite see, and it's really more my eyes. The witness that why do you say that has to do with him appearing before the commission?
Sorry, I'm.
Page
Just would you give me a moment?
Yeah.
Yeah.
Page 60, supplementary. And then there are 53 paragraphs.
Thank you, Commissioner.
And again,
I-
it's a message sent to his business manager. But your paragraph, it's operation manager. Sent to his business manager, and that's what he said. My question is, what for the commission?
Well, I mean, you've heard me already time about these threats and when they arise, and you've heard me already say about the presence of the threats after the first appearance of February, and the particular slogan. It's a slogan that is said to say. The cloud. No, I can make out the left hand side who's got his head bowed down. If you look at the square on his the basis upon doesn't obviously question the context or how this link. That is ordinary. My of the threats. It's the evidence at the commission.
Yes. Yes, but can we also agree that I mean he says these individuals. What do you consider there in that picture as A1? Because that's where he's making reference. What do you see as gestures of a threatening nature there, whatever the threat is about?
I mean, I'm not going to give evidence.
I'm not being facetious.
No, I'm not suggesting that either.
You do accept that we have to make our decision based on the facts and evidence that have been placed before
absolutely.
us.
And
so I wouldn't want him to say the commission disregarded evidence that showed threatening gestures.
And I mean, but that's why I'm saying what he should have probably done is he should have said, like the sufficiency discussion I was having earlier with the chair about identifying potential sources of threats, is maybe he should have said, in picture 1, this person has got a fist raised and that means X, or in picture 2, and so on and so forth. That explanation is not there, and that is what it is on the papers. I'm not going to give an assessment of what is threatening or what is not threatening. That's not my role to play here in front of you. So I can accept that there's an absence perhaps or a disconnect between what's stated in the affidavit and what you've got in the pictures and what the commissioner is reasonably putting to me.
Yes.
I can't take it further than that.
All right, I understand. And then lastly, the last annexure is at page 63.
I'm with you.
He says, you're taking chances, we're after you, we're gonna burn your place, you can run but can't hide, bro, we'll make sure we deal heavily by your family. On the face of it, again, on the face of it, there's no link to the commission, on the face of it.
You've heard me already, subject to that same caveat.
Yes, I know.
Then of course, I must accept that.
Okay, all right.
I noticed that Commissioner Baloyi did not read the middle text.
I'm a lady.
Exactly as it is.
I'm a lady.
I hope that's not an invitation from Commissioner Baloyi for me to read it out and not be a lady. But let's just say that the threats, such as they are, use rather colorful and robust language that we as members of the noble profession might not be used to saying in open court, but potentially about each other behind each other's backs. I'm not certain. But yes, but I would say the use of these words are indicative of a context. The use of the language and the threats as they are being made are indicative of a context. Admittedly, Commissioner Baloyi, your position is that absent the direct link to the Commission, you are in doubt about that context, and my response to you is to say, well, read it chronologically, what happens from the 6th, and that's how you understand the context. That's how I would put it.
Maybe lastly from me then, we've seen his statement on
the main statement.
The main statement
yes.
to the commission. Is it irrelevant to our determination of this application that if we form the view, maybe let me formulate it differently as an if question. If our view of the statement is that it doesn't implicate anyone, if that is our view of that statement, and so we have no expectation that when he comes to testify, he will implicate anybody. We don't have that expectation. If we didn't have that expectation, because his statement, we form a particular view about it. Is that irrelevant to our consideration of this application?
No, it is relevant. Like I was debating with the chair earlier, it's relevant in the basket of factors. What weight you attribute to that might sway it one way, or you might say it's insufficient weight and it sways it the other way. So it's not irrelevant. it is relevant, but it's not the sole determiner of the application for in-camera on the merits. So I accept that.
Thank you. Thank you,
Thank you,
Mr.
Commissioner
President.
Baloyi.
Thank you. Mr. Premier, I'm going to be brief. I think you've accepted that prayer 3 and 4 have to be modified. In their current form, there's a problem.
Absolutely.
Yes. And in prayer 3, you accept that your client is coming to testify next week.
Yes, absolutely. Unless you decide otherwise,
No.
he's going to be here.
No, not here. We're not there yet. He's coming to testify, not here yet.
You know, in principle, then I fully accept that
Unless
he's going
you
to be
abandon
giving
your
evidence next
application.
week. No, I accept that. I
Yes.
accept that.
So whoever is threatening him then knows that he's coming to testify
Yeah.
because your application says he's going to the commission.
No, sure. And I mean, they would have known that from the very least at the 6th of February when the order was read out on the record and the dates were specified.
Yes.
So, yes.
And all the WhatsApp texts that Commissioner Baloyi has taken you to relate to him, or at least some of them, to him coming to testify at the commission, correct?
Yes, yes. I mean, Commissioner Baloyi and I disagree about, seemingly disagree about whether the ones that don't are linked to the commission or not. But in my construction of those messages, in his version, that is exactly the point.
And his identity is already known. I mean, his face is all over
Yes.
the media.
Yes,
He was here the other day, I think it was the 6th, so everybody saw him.
yes.
Now, here is my problem. Accepting that those are the facts, what then justifies his evidence being in camera?
Well, I mean, I think that's if you approach it from the perspective of the horse has bolted, then there's no answer to that.
No, because here is the threat. The threat is they don't want him to go to the commission.
Yes.
But he is coming to the commission.
Yes.
So that threat becomes irrelevant because he's coming anyway.
I'm not sure you can say that it becomes irrelevant, because if they make good on the threat when he comes here to the commission, then that's indeed very relevant. What I'm trying to engage you on, Commissioner, with all due respect, is that that it might all be known and the date was already known might render the application from a strict legal sense moot if we were in front of the High Court. But we also know that the High Court has interests of justice jurisdiction to nonetheless grant relief, even potentially impractical relief, but nonetheless grant the relief where the interests of justice are satisfied. So it's not irrelevant with all due respect. It is still relevant for determination, because even though on the facts it might be quote unquote moot, you're still, I would argue, you sitting as the commission, are still clothed with your interests of justice jurisdiction that might give you some, or that might result in you giving some or other order that my client may or may not benefit from on the facts.
But
That's the difficulty we're in.
What does it achieve, him giving evidence in camera? I mean, you must look at this thing the other way. If people are threatening him because they are scared that when he comes to the commission, he's going to say things that may cause difficulties for them, it is even worse if he's giving evidence in camera, because now it means they know he's going to the commission. They know he's going to give evidence. But because they don't hear that, then he might have said something which actually causes them difficulty.
With all due respect, I think that's being a bit glib, and that's actually expecting my witness to take his hands into his, to take his life into his own hands, and to come and defy the people who are threatening him, to defy the commission by hurting him either before or after that evidence. I think it's a perhaps too strong a stance to take, to say to a witness who comes to you and says, I am concerned about my safety, I am concerned that I and my family and my businesses are going to be prejudiced and damaged and destroyed or killed in the way that these messages reference, and then for the response to be, well, come and say it all in the open light, in the, what is that famous phrase, that sunshine will disinfect all, malfeasance or whatever the case is, where his doing so is the very thing that may cause the harm to befall him. That's the point.
Mr. Permit, I said you must accept as a fact that the threats are there and take it from there. So let's accept as a fact that the threats are there, and accept as a fact that he is coming to testify
Yes.
anyway. It may or may not be here, but he will be testifying
Yes.
anyway. My simple point is, why does it have to be in camera if he's coming to testify anyway? I would understand if you said there are things that he is going to say that cannot be heard in public, because if they were heard in public, he would be in danger. But you're not saying that. So I'm still at a loss as regards why his evidence needs to be in camera.
Well-
I've accepted that there are threats, but because he's going to give evidence anyway, and he's not going to tailor his evidence depending on whether it's in camera or not in camera, you did not make that case. That's why I'm still at a loss as regards why the evidence must be in camera, because I've accepted that there are threats, nobody disputes that, nobody says
Yep.
they are not credible.
Yep.
But because he's coming to testify anyway, I don't understand why evidence must be in camera, and I don't see it in the papers.
I think, with all due respect, Commissioner Kumalo, I think I've given that response already, and I'm at risk of potentially repeating myself. But the top-level notes that I'm going to give to you, so as to not be accused of failing to answer your question, is, number one, it's the fact of the threats, which we say is a stronger factor that weighs more than what the Commissioner has put to me.
Just stop there. They don't go away whether or not he testifies in camera or in person. And
Yes.
that was my point.
Yes.
Because the threats are already there.
Yes.
Whether he testifies in camera or
Yes.
in person, they don't go away.
Yes.
So my simple question is, why then must the evidence be in camera?
But that leads me to the second point, which is what I was going to say, is that then takes the attitude from the Commission that he must come here and take his chances. And with all due respect, I think that's a pretty difficult position for my client to be in circumstances where he says to the Commission, I'm coming to you to prevent the possible threat from materializing. The threats are there, and the Commission's response then is to say, well, everybody knows as it is, come and give the evidence and see what happens. And that's really, actually it boils down to an equity and value judgment to be made by the Commission as to whether or not, in light of those threats that you yourself, Commissioner Kumalo, say to me you accept as factually existing, should be decreased in their purchase because of all these issues that we've been debating today. And our respectful submission is that that shouldn't be the case, because in exercising your discretion, that the factual existence of those threats is something that should weigh heavily on you in making your decision.
I'll accept that as your best answer.
It's the third time's the charm.
May Council please just give us a moment. Ms. Hasim, do you want to start now, or is it not best perhaps to start when we come back after lunch at 2 p.m.?
Chair, may I just consult with because there's another... Chair, that would be preferable because it's also time for Friday prayers.
All right.
Thank you.
Let's adjourn and resume at 2 p.m. Thank you.
All right, we said we'd be back at 2. It's 1 minute 2. Please make sure your cell phones are off. Thank you.
Ms. Azim?
Thank you, Chair. The engagement with my learned friend from the panel has rendered most of my task here redundant, I think. But I'll do my best to cover what I wanted to cover and not dwell on some aspects that have been already fully canvassed with my learned friend. So, Chair, what I propose to do is to address the following in my submissions to the Commission. And the first is the legal framework. The second is the reason why granting the application in the particular circumstances of this case is not justified. And in short, what I submit to the Commission is that an in-camera hearing will not offer the protection or remove the threat that Mr. Karim seeks from having this application granted. And the third is to propose an alternative course that may have better protection, perhaps, for Mr. Karim than an in-camera application. So, Chair, let me first say that although my learned friend was a bit dismissive about the attitude of the evidence leaders to this application, we in fact take quite seriously requests for in-camera evidence. We've moved applications before you in the past in circumstances where the facts were more cogent than in this case. And even there, the Commission has not granted our application in the terms that we sought. So even though there were in-camera witnesses, they were partially in-camera, which wasn't the initial request that was sought for those witnesses, and I'll come back to that. But we moved those applications because we take seriously threats to witnesses. So the starting point is the legal framework and Section 4 of the Commissions Act, which governs this proceedings. And what Section 4 makes very clear is that all the evidence and addresses heard by the Commission shall be heard in public. That is the first thing to say about the Commissions Act. That statutory requirement is given effect in the rules of the Commission, which states that hearings of the Commission will be held in public. Rule 4 also expressly recognizes that there may be circumstances in which it is appropriate for hearings to be conducted in camera. The question is whether these are the appropriate circumstances. And according to Rule 9.2 of the rules of this Commission, that determination lies in the discretion of the Chair. My learned friend refers to a series of judgments, including what we call the Masetla judgment, SABC versus NDPP, and others. And the propositions there for when restrictions on openness is appropriate are well established. But they don't do the work for Mr. Karim in this application. The proceedings, and for several reasons, and it is important to say that the proceedings here don't concern the same kind of litigation, inter partes litigation, in which there is a list. It is a public commission of inquiry, and that's relevant when taking into account the weighing up and the balancing exercise that comes once a threat is established. Because the purpose of a commission of inquiry is not only to investigate and to fact find. It serves an important additional purpose, and that is of public accountability in a matter of high public interest. And for that proposition, Commissioners, I'll cite two authorities. The first is the Minister of Police versus the Premier of the Western Cape, and that's to be found at 2014, Volume 1, South African Law Reports, page 1, Judgment of the Constitutional Court, and the specific paragraph that establishes this is paragraph 45. It developed the SARFU judgment, and it emphasized that a commission's role is not exhausted by merely advising the executive or the president in this case, but that in addition to doing that, a commission may serve, and in the language of that judgment, a deeper public purpose, especially in times of widespread public disquiet. The second authority is the case of Secretary of the Judicial Commission of Inquiry into allegations of state capture versus Zuma. And that's to be found in the South African Law Reports 2021, Volume 5, page 1, Constitutional Court Judgment, at paragraph 5 in particular, where there, what the court said, again, is that in addition to the advisory and recommendation and policy advising function of a commission, it also serves a purpose of having a public inquiry in respect of matters of high public concern. And the court said the purpose of a public hearing there is to restore public confidence in the institution in which the matter that caused concern arose, which is very similar to what this commission is dealing with. The objective, said the court, is to reveal the truth to the public pertaining to the matter that gives rise to the public concern. So that context in which this commission sits is important in assessing whether appropriate circumstances prevail that justify the granting of the application that's brought today. Against that backdrop, of that legal framework, let me say then that the facts here don't warrant an in-camera application. The applicant brings the application on the basis that he fears for his safety. In fact, he goes further than that. He talks about the safety of more than 1,500 employees. He says, if he testifies in public, that's the risk. He's also referred, apart from the threats that he's received, he refers to the backdrop of 2 witnesses, but we've now covered that extensively this morning, and it was 1 witness that was killed. The second, Mr. Pretorius, was not a witness before this commission. And of course, the investigation is still ongoing as to the circumstances of the assassination of witness D. And so that's been covered again extensively. I'm not going to get into detail about that, but it is important again in weighing up what this application rests, the grounds upon which this application rests. Mr. Karim attaches text messages that he has received from unknown numbers, which appear to be threatening. We don't know the context, further context of those text messages. We don't know what the potential sources are of those text messages. We don't know whether there's anything that is, whether there's any hostility or dispute or that's happening within Mr. Karim's workplace that may give rise to this. We don't know what the source of the threats are. But that there are threats, on the face of it, appear to be clear. They're attached to his application. So we're not dismissive of that, and my submissions to the Commission shouldn't be misunderstood as being a dismissive of the concerns raised by Mr. Karim. But the reality is that the relief that Mr. Karim seeks is not going to assist him. The reality is that Mr. Karim is known to the public. His application in the High Court to delay his appearance before this commission was widely broadcast. He then appeared before this commission in order to secure a postponement by agreement. Those proceedings were widely broadcast. In those open proceedings, the commission issued a ruling that Mr. Karim is to be present on the 9th and 10th of March for the purposes of leading his evidence, providing his version that he wishes to place before the commission, and to be questioned in relation to his evidence, particularly on allegations that have been made by other witnesses that have come to the commission. Now, and let me say this, in the answering affidavit at paragraph 5.1, it sets out a sample of national media coverage in which Mr. Karim's name and pictures are displayed. And that's in relation to the High Court application. In paragraph 5.2 of the answering affidavit, there are examples of widespread coverage that Mr. Karim will be testifying on 9 and 10 March, and those examples include visual images of Mr. Karim's face. So there is no secrecy at all that it will be Mr. Karim who will be testifying in the commission on 9 and 10 March. What Mr. Karim says in his supplementary affidavit, though, is the following. He says, if my in-camera relief is granted, at best, the makers of these threats will simply not know when, if, or how I give evidence, as the very fact of my doing so will be sealed. And Chair, that is to be found at page 55 of the paginated pleadings bundle, paragraph 9.2 of the supplementary affidavit. Roughly halfway down that paragraph. I want to emphasize this. What he says is that the makers of the threats will not know when, if, or how I gave evidence, as the very fact of my doing so will be sealed. But that's not correct. First of all, it is known. It is known when he will be testifying, and it's known widely as we've set out in the answering affidavit. Second, Mr. Karim accepts in his notice of motion that he will testify, and as my learned friend has said earlier this morning, it's accepted that he will testify 9 and 10 March. And so in the notice of motion, the paragraph 3, what paragraph 3 requires is just that the hearing is held in camera on those days. Third, it's not at all a given that that in-camera hearing or that closed session will protect the witness. In fact, it may make him more vulnerable, since those who are threatening him may assume that he has implicated them or given evidence problematic to them when he has not. So secrecy can actually amplify a witness's vulnerability by signaling that the witness is exceptional or hidden, and it may just fuel speculation and targeting rather than quell speculation or threats. My learned friend said just testifying at all is a risk, something to that effect, and I'm not sure that I understood it fully. But again, that doesn't assist, because what we do know is that Mr. Karim is not saying that he will not come to testify. He will come to testify. All he asks is that it should be made in camera, but not disclosing his face or his voice is a practically futile measure because his voice and his face is so well disclosed. And I must say that Mr. Karim has not raised confidentiality or tried to assert confidentiality over his intended evidence as a ground upon which an in-camera hearing is warranted. So we're only dealing with the question of the threats. And I say that he's not raised that because it's not raised on the papers, but also because when one has regard to the statement, and although Mr. Karim repeatedly refused to comply with this Commission's ruling on 6 Feb that a written statement be provided by 27 February, he has now filed it. And nothing in that statement appears to place the witness at risk through exposure of third parties in any wrongdoing. The contents of the statement do not disclose any information that was not already disclosed in a public setting before the High Court. So there really will be no practical purpose served by an in-camera hearing. And the threat won't be removed by an in-camera hearing. The threat that, such as it is that has been put up in the text messages. And I'm assuming for the purposes of my argument that those are credible threats. Now, with regard to the other in-camera applications, there have been 8 witnesses who have applied to give evidence in camera before this Commission. All but one of these witnesses were required to testify only partially in camera. That is, in public session, with only their faces concealed. The grounds advanced by those witnesses in their applications were either that testifying in open session would risk compromising ongoing criminal investigations or serious risks to their physical safety. The reason for concealing the faces of those witnesses was because they were also in witness protection, and their facial identification would have rendered the witness protection measures ineffective and would have materially jeopardized their safety. Their faces were not known to the public, those witnesses, unlike Mr. Karim. Here, his identity and appearance are already in the public domain, as is apparent from the extensive media coverage annexed to the answering affidavit. Masking the witness's face would therefore serve no practical protective purpose. So in those circumstances, even a partial in-camera hearing would be devoid of a rational foundation and cannot be justified on the facts before the Commission. So in these circumstances, Chair, in the circumstances of the already public litigation that took place before coming to the Commission, and then the public appearance before this Commission on the 6th of February, one is hard-pressed to understand how another 2 days of public process will increase the risk to the witness. It is true that there is public attention on the proceedings of this Commission. By their nature, all commissions established under the Act are required to be public as a default position. All the witnesses who have testified in open session in this Commission have had to deal with this at great personal discomfort. Having regard to what I've said about the public knowledge of the witness's identity and the dates for his evidence, there's no reason to privilege this witness by shielding him from public view. And there's been no argument that can be sustained on the founding affidavit or the supplementary affidavit before the Commission that the in-camera hearing would provide protection. As I said, I think it may have be counterproductive as far as safety goes. I I noted my learned friend, because this point was raised by Commissioner Khumalo about whether it wouldn't be counterproductive. And my learned friend said that might be a glib answer. And first of all, it's not. It's just a practical reality. And it's a practical reality that Mr. Karim has difficulty overcoming. But to assure the Commission and Mr. Karim and his team that from our perspective as evidence leaders, it's not a glib response. What I submit to the Commission is that there are measures of protection that may be provided to the witness. And I must say that in the supplementary affidavit, the witness says the following, and that's at 9.3.4, paragraph 9.3.4 of the supplementary affidavit. What the witness says is, I quote, "Unlike the Commission and some of its staff that have the benefit of security details paid for by the state from taxpayer funding, I have had to undertake at huge expense and prejudice funding security for my family and me." So the witness has complained that while there's protection provided to the Commission and its staff, he's had to foot the bill for his own protection. I want to clarify and place on record that I've been advised by the Commission's head of security that the Commission has previously offered the witness protection services. I understand that he declined the offer as they already had arrangements in place. The offer, however, remains. And I would go so far as to propose, Chair, that in light of the threats received, the Commission could better protect the witness in other ways, not through an in-camera application, but by renewing its offer of protection services that was made earlier, and to consider the contours of the offer of the protection services, whether it's transit protection or static or both, and to do so on the basis of a threat and risk assessment, which I think, in fact, first of all, a threat and risk assessment with the assistance of the state security or crime intelligence or both would actually be important, because a properly resourced TRA is likely to identify the source and nature of the threat more expeditiously than a report made at the local police station. So it goes to the point, Chair, that you raised at the outset about the credibility of the threat, the source of the threat, what actually lies behind it. And having a well-resourced threat and risk assessment made available to the witness will provide a more meaningful measure of protection for the witness. And I would propose that those measures be considered, and if the threat and risk assessment shows that there's a basis and for providing, whatever range of services are necessary, then that can be considered by the Commission, and if necessary, it may even be in place for the duration of the work of the Commission. And again, I say so on the advice of the head of security for the Commission. But that is a meaningful way to address what the witness has brought to this Commission, the risk that he says that he faces and the threats that he's received. It's not the first time that the Commission would be offering services. It's done so for other witnesses who have come, and those witnesses have testified in open. So, in open session. So those are my submissions on the application itself. There are a few other issues I just would like to touch on very quickly. The first is the issue of the bundle that is to be provided to the witness. And I'd like to again clarify that that bundle is not there was a bundle that was provided to the witness some time ago. And what is to be provided today are additional documents that will be used for the purposes of examination of the witness on the 9th and 10th of March. So it's the original bundle plus some additional documents. So the delay is not for the provision of an entire set of documents. It is for the additional documents. The reason it couldn't be provided earlier was because the evidence leaders were awaiting the statement, which only arrived on the 4th of March, the statement that was due on the 27th of February. And the reason for that has got nothing to do with ambushing. The witness seems to be paranoid about the posture of the commission. And there's really no basis to be concerned about that. The purpose of the statement is something that is common practice by all commissions, in fact, not just this commission. A witness comes, a witness provides a statement. It's for the benefit of the witness. The witness gets to provide his or her version unfiltered by the evidence leaders. That was why it was important to get the statement. And of course, if the witness were to say he didn't wish not to provide a statement in the end, well, there's nothing much that the commission could do about that, but the cross-examination would continue in the absence then of a version in writing by the witness. So the second thing is what it does is it allows the issues to crystallize, to understand what is actually in dispute and not in dispute, what are the things we need to cover with the witness.
You are left
only upon receiving.
You are left with 5 minutes.
Thank you, Chair. I'll be done in 4. And so it was necessary to receive that so that we could crystallize the issues and know what documents needed to be added to this bundle. It will be provided today. The second is on the answering affidavit. The purpose of the answering affidavit was to put up those media reports so that the commission, so that it was properly placed before the commission, so you could have regard to it in determining this and considering the argument of the evidence leaders and where we are coming from when we say practically there is no, it would be futile to have an in-camera hearing. We needed to set that out. That was the purpose of the answering affidavit, not to respond ad seriatim to the applicant's affidavit. So to the extent that there were issues like the 2 witness issues that were not addressed, that was the only reason why it wasn't addressed. Again, we're not in adversarial mode here with the witness. We just wanted to make the evidence of the extensive media coverage available to the Commission properly. So I'm going to resist the provocation by Mr. Karim, I won't say by my learned friend, in his affidavits and his remarks about the Commission and the Commission staff and the evidence leaders. I could say more, but maybe I'll just leave it at what Justice Fisher said in her judgment when she was determining the urgent application that was before her and about what she thought was the unreasonable conduct of the witness in paragraph 19 of her judgment. I won't say anything further on that score. I'll leave it at that, Chair. So that really is our response. I am here addressing the Commission on behalf of the evidence leaders to this in-camera application, Chair.
Thank you, Ms. Hassim. I have just one issue. You emphasize, of course, you've raised a whole lot of other issues, but you've emphasized the question of the High Court application and therefore the fact that Mr. Karim was brought into the public domain, pictures and all, on that occasion. And also that this happened as well when he appeared here. If I understood Mr. Prem's argument correctly, he's saying none of that changes the situation, which is that after the High Court application, after that appearance, it's only then, thereafter, that there were threats, and that the application relates to the threats, and not so much what had happened historically, even if that was recent history, of course. So why the emphasis on the High Court application and also the appearance here?
It's the emphasis is important, and it's not historical, Chair. And it's not about the High Court application and what it was about or anything like that. What is important is that as a result of the application and the public appearances that the witness has already been involved in, whether High Court or here, his identity is known. So it is, and that can't be changed. It's because of the High Court application and his appearance here that his identity is known. And that's the only point that's the relevance of the High Court proceedings and the 6 February appearance. It's in that context that there were images of his face, that there was video coverage of his appearance before this commission, and therefore he is known. So the relevance of it is, what does in-camera hearing, how does it serve the witness in protecting him? By my learned friend's argument, the only way in which the threat would be removed is if he did not testify at all before the commission. That's the only way the threat would be removed. But as it stands now, he is publicly known. His face is known. It's known that he's going to be here on Monday and Tuesday. To just pull a curtain over it and have the hearing
not necessarily here, because at this stage you do not know what my order or direction will be.
Fair enough. Fair enough. I'm saying if it were to be in open session, it would be the dates are known, and so the identity and the revelation of the identity of the witness around that time, the High Court application and appearing here, has made the in-camera application redundant. That's really the only point of referring to those.
Thank you, Ms. Hassim.
Isn't a further factor that it's known that he's going to testify already from the date that he filed his application in the High Court, and when he appeared here and a date was given. So the world, whoever's making those threats, knows that he's been ordered to come and testify on Monday and Tuesday, the 9th and the 10th. And the application as it stands now, it doesn't ask that he does not testify on the 9th and the 10th. It doesn't. So the assumption has to be, or the prevailing position as matters stand, is that he will testify on the 9th and the 10th. So whoever he's afraid of knows that he is testifying. He's not being excused. You want to say something about that?
Commissioner Broy, that really is it. It's a practical point, really. And it's why I referred to that paragraph 9.2 of the supplementary affidavit, because what the witness says is that the makers of the threats will not know when, if, or how I give evidence. That's just not true. The makers of the threats will know when, if, and how Mr. Karim will be giving evidence.
Thank you. We'll hear what Mr. Premit says about that.
Just maybe 1.5 points from me. For the purposes of this application, we should accept that the threats are credible, because there's no suggestion that they are not. You agree?
All my submissions are on the basis of accepting that the threats are credible.
So we must start from the premise that there are threats. Now, accepting that as a fact, do you think an in-camera hearing of the evidence would eliminate those threats? I mean, based on what we have heard. I'm not asking for your opinion, but based on the evidence that is before us.
Well, okay, so let me explain what I say when I say the threats are credible. What I mean is, I think it would indeed be glib to not take threats seriously. However, there is an issue of insufficiency of the evidence. Some of it was already, and I didn't go there because it was covered already by Commissioner Baloy, about whether the messages that are attached to the affidavits actually show that it's a threat that is emanating from this commission, or whether it has to do with something else. And I've heard my learned friend say, well, you've got to see it in the context of when the threats were made. I accept that, but it's not a full answer. The evidence is insufficient. So I just want to be understood properly when I say it's credible. I just mean that I think it would, from my perspective, I take it seriously, but it's not the application, the sufficiency of the evidence for the purpose of the application doesn't satisfy, I think, what this commission needs to determine. So,
I understood Mr. Premier to be saying, because we don't know where it's coming from, we must err on the side of caution. Just because we're not certain that it's related to the commission does not mean it is not. Sorry, Commissioner Kamala. So the first is the issue of the sufficiency of the evidence, but it's also not knowing, it's precisely not knowing that, which is why at the tail end of my submissions, I propose that, well, let's get to the bottom of it. Where is the threat coming from? And how can the commission assist the witness in that regard? And that would be, as I said, more meaningful protection than an in-camera application, because everybody will know that the person behind the curtain is the Wizard of Oz.
Thank you, Ms. Hassim. Mr. Premier?
Yes, thank you, Chair.
Just a minute.
Oh, apologies.
Only 10 minutes, Mr. Premier.
Is that protected time? Or in toto?
All told.
I have 14 points to make very briefly in reply.
Sorry,
Sure.
was that 14?
14, yes.
Sure.
I'll do it in 10 minutes, but I will...
All right.
I have 14 points to...
10 protected.
Okay, I take that. I take that. Thank you, Chair. Let's start at the end. My learned friend says that Mr. Karim will come here on the 9th and 10th if the in-camera application is granted, and all that will be done is his voice is going to be blurred, or they're going to distort his voice so that he's not known. My learned friend is interrupting. I apologize. I don't know if this is going to cut into my protected time. That's how I understood the submission, but Ms. Hassim, yes?
Chair, can I just correct it, because you may go down a path then, Mr. Premier, that is not warranted. What I'm not a distorted voice or that kind of thing. It would be in camera. That is what's requested. It would be a closed, sealed session.
Yes, but the specifics of that request are set out at pages 11 and 12 of the founding affidavit, where at paragraph 23, the witness says, it appears that the individuals are tracking my movements and will be monitoring whether I attend at the Commission's current premises. In this regard, I request that my evidence be led in camera and virtually, alternatively, at an undisclosed location. And then at paragraph 25, it goes on to talk about the purpose of moving the application in the context of being monitored. So actually, the presentation that the in-camera relief is simply to come here in secret on the 9th and the 10th, properly construed is not that at all. It's about getting appropriate directions from the Commission for alternative accommodations that will give the protection of an in-camera session in the way that my learned friend has said, if we come here on the 9th and the 10th, it won't be. So I agree with my learned friend's submission in that regard. May I just also say regarding this sudden offer that is being made about security and whatever else might be the case. I heard my learned friend to say that the head of security made a direct offer to this witness, i.e. my client, and I am instructed by my instructing attorney that no such offer has ever been made. And therefore, the further submission that that offer was rejected also falls to the wayside, because you can't reject something that you haven't actually received. But let's just assume it was made. Why did we have to bring an application and have to come to fight a full in-camera hearing when that is a practical offer that the Commission could have made earlier? And so my learned friend says, rather conveniently, we're not here in adversarial proceedings, we're here in an inquisitorial context. But she then tenders at the last moment, literally in her answer in the in-camera application, something that could have remedied my client's prejudice, which has never been tendered before and has never meaningfully been engaged. Why is it that we are subject to this kind of treatment in this particular context? Regarding the other points that I need to make, that's 2 of the 14, by the way. Yes, the bundle is coming. The bundle was meant to be served 2 business days after the witness statement was filed. That was filed on the 4th of March at 9 o'clock. I'm instructed that it's almost 20 to 3, 2 business days later, and we still haven't received the bundle. So I must raise that in the context of the ongoing prejudice that my client faces at the hands of the commission's, and I say this with, in a slightly guarded manner, heavy-handedness in how they have treated my client. So regarding also the throwaway remark that my client is seeking to be privileged as a witness is utterly unacceptable with all due respect. He's not asking for any privilege. He's asking for a procedural determination by the Commission of the rights that the Commission's own rules give him. And to present it as being a privilege actually suggests that the Commission characterizes my client's application as seeking something to which he is not entitled. And that's not correct, because what he is asking from the Commission is something that the Commission's own rules entitle him to. Regarding some of the authorities that my learned friend cited, may I just make 3 brief points about that? The first one is that I sent my learned friend my list of authorities earlier. I asked her to do the same. She didn't, but it's fine. Point number 2 is that those authorities, with all due respect, are irrelevant to the issue at hand. Those speak about the important public function that a commission is supposed to play. That's trite. It's common cause between the parties. The question we have to ask ourselves is whether or not that, as the default principle and the baseline, can be derogated from, having regard to the 6 authorities that I cited, which said that openness is not by default, it's not absolute, and that it can be derogated from in circumstances where, for example, there's a serious threat to security. And whilst I'm just complaining about this, let me also say that this was not the case put up in the answering affidavit, so this is the first time that we're hearing about that. But be that as it may, we're not in a strict court proceeding where affidavits need to be dealt with in that way, I suppose. Let me just also say that we have things that are thrown at us that we learn about for the first time regarding, apparently it was 12 witnesses or 8 other witnesses and all these other kinds of things and what they did or didn't do or whatever the case might be. This is knowledge that is squarely within the Commission's, and when I say the Commission, I mean the evidence leaders, the staff and the attorneys within their knowledge. And instead of then drawing us into a proceeding of this kind, this information could have been tendered to us well in advance and we could have had a reasonable engagement with each other. The only reason that we are here at the moment from the Commission is precisely because we are treated in the manner in which we are treated. Chair, I see I have 4 more minutes, which I will try to use to the best of my ability. And also, with all due respect, the fact that we are here now in the circumstances in which we are here now demonstrates not only the abusiveness that my client has been subjected to with respect, it's also that this whole exercise by the time we're here has been rendered futile because of the manner in which the proceeding has unfolded in front of the Commission. So even if the Commission was still minded to give my client some form of meaningful relief, regrettably, most of the relief that he could otherwise, or most of the relief that he could otherwise have been entitled to is now lost because of the way in which this in-camera application has unfolded in front of the Commission. And the point that needs to be repeated is that it's not the public nature of my client's exposure to public knowledge that gives rise to the in-camera. It's the existence, the factual existence of the threats and the timing of those threats and the way that they have arisen. And so in those circumstances, we would say that the appropriate thing to do here is to grant my client in-camera relief. If it has to change Schedule A, who's included and who's not included, that is something that the Commission will determine and we will respect. And the Commission will also apply its mind to what is said at pages 11 and 12, paragraphs 23 onwards of the founding affidavit regarding the modality of that evidence. And may I just conclude then on this point in 2 minutes to spare, is that one of the letters that were placed in front of the Commission was an explicit request for confirmation that all of the correspondence in this matter, as well as all of the pleadings, had been promptly placed in front of the commissioners because of the fact that we required a ruling before the 25th. And that was never responded to despite the request being made. And the reason I raise that is because that concretizes the prejudice that my client faces in circumstances where he engages the Commission evidence leaders and staff on one hand, and things don't necessarily go through to the commissioners in the way that we don't know whether it does or it doesn't, and then he's caught with the consequences arising from the way in which the Commission's evidence leaders and staff choose to handle requests made of them, including requests where matters are asked to be raised with the commissioners on an expedited and time-sensitive timeline. And so, quite frankly, having regard to all of that, and the fact that factually at the end of the day, everyone accepts that these are credible threats, and that they do exist as a matter of fact and as a matter of the record, we would pray for the relief sought in the notice of motion, subject to those amendments that I have suggested are possible amendments like the one I discussed with Commissioner Khumalo. May I please take an instruction? Thank you, Chair.
Mr. Premier, I'm concerned that with the posture, and I'm concerned because I am not aware of the facts. I don't see the facts, maybe let me say it. I don't see the facts on which you base the kind of contentions or statements that you're making. You have this consistent complaint that your client is being treated exceptionally badly. He's being victimized, high-handedness. In fact, if one went through your client's affidavit, there's really quite a number of concerning statements. You know, in your supplementary affidavit 932, you speak about brinksmanship. In 934, you speak about a fishing expedition that the Commission wanted his statement as part of a fishing expedition. But over and above that, there's this hyped up criticism of how he's being dealt with. You haven't placed to us, before us, facts that support those kind of strong statements. And I think there is a responsibility, especially for, at least as far as I'm concerned, there is a responsibility for legal practitioners to advise their clients when a statement is required by the Commission, because our rules say so, because the chairperson directs statements must be filed. I think I think you'll agree with me that legal representatives have a responsibility to say to the client, you can't call it a fishing expedition. Statements must be filed, right? We do have that responsibility.
Absolutely.
And here there's this gratuitous statements about how badly he's been treated, including on something like this. It's not backed up by anything in the conduct of the Commission. You know, the chair earlier dealt with you, spoke to you about some of the language and gratuitous statements that are made, but in fact, there's quite a number of them here. I'm concerned that your client is on a path that seeks to publicly create the impression that this Commission has got something against him. And there's no basis, absolutely no basis. And I want you to deal with just one example. Your attorneys wrote a letter requiring a response and rulings by a certain date. They had unilaterally fixed dates. And there was no justification in that letter why the Commission must make rulings by a certain date. We're just told Just give us rulings by this date. You're complaining about the response that you got. We didn't give you the ruling on the date that your attorney demanded it, because that's what it was. You're complaining about that as if it was there for your client to take. It was for the attorney to write, and the commission must give a ruling on the 25th, and if we don't give a ruling on the date that has been dictated by your attorney, we are treating your client unfairly. Something that I can answer directly to without having to file an affidavit is the demand to place it before the commission, that letter that said, please place this before the commission. Commissioners, in fact, it happened. And your attorney got a response saying, we acknowledge receipt. It will be placed before the commissioners and they will deal with it in due course. There is that kind of response that was sent. And I say that because I know it happened. But that's not even the nub or the essence of what I'm speaking to. I'm speaking to this tone, this consistent tone since morning, that your client is being treated unfairly. You haven't suggested, or he hasn't suggested, why we would do that to him. He hasn't. He's just been happy to say, I'm being treated unfairly. There's this high-handedness. There isn't. He appeared here. He was told to file a statement by a certain date. He did not file by that date. Instead, he wrote a letter to say, well, give me directives. He doesn't file on that day. He's told you have to file. So I don't see any facts here. And it's important what you're saying because it carries. And it carries. This is a very public process. And it carries, and I think it should be called out. If your client has got facts, he must list them and let the reasonable person judge on that. But as matters stand, there's nothing of sorts. It's just gratuitous statements. What fishing expedition, what interest would the commission have, and why him, when all other witnesses, we've had many witnesses appearing. This is the first time that we have a witness who says, well, you want my statement as part of your fishing expedition. We've had in camera people applying. They have happily filed statements that set out why they should be heard in camera. This is the first time that we get a complaint that this is a fishing expedition. I'm really, and you can comment as you wish, but I'm really expressing a displeasure with the conduct of Mr. Karim, but also because it's not substantiated by anything that he has put before us. You may comment if you want to.
Thank you, Chair. Commissioner Baloyi, I'm now going to read from the correspondence because I don't know if the correspondence bundle has been placed in front of you in the way that we asked. But on the day that the application was launched on the 18th of February, this is what the attorneys say on the record with prejudice.
The postponement. What application?
No. This is on the 18th of February when this application for in-camera is launched, Commissioner Baloyi. The attorneys say, as you would appreciate, due to the sensitivity and urgency of the matter, bearing in mind the date for the submission of our client's statement, in respect of his evidence, we request the aforementioned application to be urgently considered by the chairperson and such ruling is issued by or before the 25th. In that same letter, it says, in our respectful view, it can be decided without oral submissions on the basis of the application. Should the chairperson require submissions, we are amenable to do so at a time that is mutually suitable, taking into consideration the need for a ruling by or before the 25th. And you'll remember that is coupled with an application that seeks condonation for non-compliance, both in terms of the rules as it applies to the timing of the in-camera, but also explicitly says, I need a direction in respect of the filing of the statement so I know what my position is come the filing deadline. On that day, Commissioner Baloyi, the response from Mr. Popkas says, it's not that it's being placed in front of the commissioners. It says instead, we confirm that same will be relayed to the secretary and evidence leader shortly, and we will revert with formal instructions in due course. And then 5 days lapse. And on the 23rd of February, a letter is written, and it's a 2-page letter, and I'm not going to read all of it. But what the attorneys say is, kindly advise whether the application has been served and further when we can expect a response. In the event the application has not been served, what are the reasons? We remind you of the urgency in response to our client's application premised on the order of the Commission. And we refer you to what we set out in paragraph 7, which is what I read out about that 25th deadline. We reiterate that request. And then on that same day, we get a response that says, we acknowledge receipt of your correspondence and confirm that same will be directed to the relevant functionaries for consideration.
My point, Mr. Premier, is how does it all justify this is victimization? That's my point. My point is, remember where I started. I said there's this consistent theme that Mr. Karim is being treated exceptionally badly, victimized. You've said, I think we've been adversarial. The Commission has been adversarial towards him. All the strongest words that he could think of are in his affidavit about how badly he's being treated. But not just badly, but like he's being targeted, he's being victimized. And that's my issue, that sequence of correspondence happened as it did, right? How does it translate? When do we get to the point where you say, this is my client being particularly victimized? That's why I referred, and for me, that's an easy example about the statement that, all witnesses have to submit statements. You have a witness say, oh, this is a fishing expedition. I've asked to be heard in camera. Now you want my statement. And you want my statement because you want a peek, to have a peek into what I'm going to see. What I'm saying is, surely, what interest do we have, right? Why would we want to fish when we're going to have a witness here? He will come and testify. We'll ask him all the questions we want to ask. Absolutely. Yes, so there's not, basically the point I'm making is there is no basis for this strenuous complaint that is being put out there that this particular witness, and just him, because we've never had this complaint, just him, why would we treat him badly? Why? The one witness who came here applied for a postponement on the basis I don't have documents, I have people who are, my lawyers are not going to be available, actually got a very generous postponement, right? To go get ready, have your lawyers available. That you don't, as you say, context. That context you don't speak to, but you nitpicking on matters of engagement with the evidence leaders, with the attorneys, and you elevate it, or I accept you're a creature of instructions, and so it's not your personal positions that you're putting forward. But why he would be targeted by the Commission? What's there to gain for the Commission? And I think those are critical questions that should be asked before he puts stuff like this on, in the public domain.
Thank you, Chair. Through you, Chair. When I was engaging with the Chair in the morning about the other instances of prejudice claimed by my client, that was a cumulative assessment of not only this chain of correspondence, but other instances where the Commission has conducted itself in a way that reasonably leads my client to believe that he is being treated in the way that he is. I understand what Commissioner Baloy is saying to me, that in Commissioner Baloy's view, there is no basis upon which to make such a statement, and that the stridency of the statements is a concern for Commissioner Baloy, but more broadly than that, that it's a concern insofar as the integrity of this commission as it may be viewed in the public. And Commissioner Baloy, I would entirely agree with you. The consistent complaint from my client has been that the Commission has a set of rules. There are instances where not the commissioners sitting on bank in front of me, but through the evidence leaders or the attorneys or the staff or whatever the case might be, there are instances where non-compliance with those rules are identified. That may or may not turn out on legal interpretation and whether that view is right or wrong. But what it implicates is that my client is the subject of coercive force by this Commission. And unless my client is represented by a legal...
Coercive force having manifested where? Just tell us
It's the
when.
threat of the coercive force. I'm not saying that there has been coercive force. I'm saying at each one of these instances that you've put to me, where the stridency emerges from Mr. Karim and his legal team, I'm saying that in each one of those instances, the threat of coercive force hangs over my client, that if he is found to be in breach of the Commission's rules, or what, even where to be found in breach of those Commission's rules is subject to a legal debate where his legal representatives say, actually, the Commission is not following its rules in the first place. So why
No, can we just clarify this? You say he's the subject of the threat. I understand you to be saying the threat of coercive force, but that's true for everyone who appears before us. If they haven't complied with a directive in the way that your client did not, right? There was an order by the chair. You must file your statement by a certain date.
Yes.
Now, there's nothing exceptional about your client on that kind of order. And when he doesn't comply with it, to say that you will be subjected to the powers that we have, that you will be held in contempt of the Commission because you haven't complied with a ruling, a lawful ruling of the chairperson. There's absolutely nothing wrong with that, and there's nothing to complain about.
No,
he may justify himself and say, I didn't comply because I was waiting. I was hoping you will give me a directive just like I asked for, right? He could give that as an excuse for non-compliance, but as a matter of law before us here, right? If you don't comply with the directive of the chairperson, you are in contempt. Whether we act or we postpone acting is a different matter. So it's an inaccurate reflection of the position to say that, well, he's being unfairly subjected to coercive force because he has been told he's in contempt and therefore he will be, measures will be taken against him. Sorry, I don't understand that complaint.
No, that's not the complaint, because we're not complaining about the trite proposition that the Commission has the power to use coercive force in instances of non-compliance. What we're overlooking, with all due respect, Commissioner Baloy, in the way in which you've put that limited factual scenario to me, is that there was an application as an intervening fact to say, please define.
That application did not displace, there was never a suggestion from the Commission, Mr. Premier, that because there's a pending application, you don't have to file. And the Commission doesn't get dictated upon by a witness who decides, I do have a ruling, I have a clear ruling to file by a certain date, but you know what? I'm not going to file. I'm writing a letter to say, give me directives, I have a pending application, therefore I'm not filing. That's a binding on the Commission. He was given a clear directive and he was in contempt of the directive, simple. But with
all due respect, Commissioner Baloy, the ruling was asked for before the statement was due. And that's why we can't simply ignore the factual intervention of the application. If the application was dismissed by the 25th, then he would have had to file on the 27th. We can't deal with the hypothetical of non-compliance without factoring in the fact that the witness himself came to the Commission and said, I know what my obligation is, but here's a related issue I need you to decide upon before my statement is due to help me clarify what my obligations are.
The problem isn't that before, that he determined, he determined for us, before I file my statement, give me a directive. And then when he doesn't get that directive, he chooses not to file his statement. That is where the problem is. And I'm not sure why we're having this argument when in fact the reality, the factual reality is there was a directive. It had a fixed date for compliance. He did not comply. He has an explanation. And that's my complaint, if it's a complaint at all, for lack of a better word, is that he superimposed before the statement was due, between the date of the directive and before the statement was due, He then superimposes something. He says, give me a directive. And then he goes and make a decision, I'm not filing because they didn't give me the directive on that day. And the simple point I'm making to you, and that I didn't expect would be such an issue of contention, is that he wasn't entitled to do that. He did it anyway, but he wasn't entitled to sit back because he doesn't have the directive that is asked for and that he has put us on terms, by the way. He puts us on terms to give him a directive by a certain date. When we don't give him that directive by that date, the simple point I'm making is he wasn't entitled not to file his statement in accordance with the directive. And when he is told that you did wrong by not filing by that date, it's not open to him to say, I'm being victimized. That's the simple point I'm making. It's not open to him to say that.
Unless perhaps I'm wrong on some legal basis, it seems to me like somebody that were to act as if there is an interdict in place when in fact there is none.
Mr. Chair, may I say something on this?
Not in the middle of Mr. Premi's
Oh, sorry.
argument.
I thought you...
No, the
Yes,
commissioners
Mr.
are very
Premier,
active on a Friday afternoon. I'm not done.
Please respond to Commissioner
I hear
Baloy's
exactly
question.
what Commissioner Baloy says. I think where Commissioner Baloy and I depart company is let's use a high court type of scenario. A high court gives an order that is going to, compliance with which is going to have to occur by the 27th of February. Let's use our exact dates. And before the 27th of February, an application is placed before the High Court that says, I need you to determine an issue, whether rightfully or wrongfully, whether imposed unilaterally, whether placed on terms. The fact of the matter is an application is launched before the compliance date to say in the High Court, determine the terms of my compliance, because I'm concerned if I comply in the way I'm currently expected to comply, that's going to cause me some or other prejudice or harm or whatever the case might be. I think where Commissioner Baloy and I part ways is that, on my understanding, given that it wasn't just a letter, it was also an application for formal relief under the Commission's rules with a prayer for condonation with the associated timeline, that demonstrates an absence of willfulness for the purposes of the so-called non-compliance, because there's a legal issue that is sought to be determined before that compliance and or non-compliance can arise. But I've heard what Commissioner Baloy has said, and Commissioner Baloy's view is that is not correct, and that notwithstanding your application, and please correct me if I'm wrong, you actually should have complied, and that your failure to comply is what has caused the concern for the Commission. I hear that, and I accept the remarks made by Commissioner Baloy. Obviously I do, but I would say that the fullness of the answer that I can give is that he didn't sit back and simply not comply. He came to the very body that will determine the consequences of his compliance or non-compliance on the 27th, and said, please give me a directive on this particular issue that is materially connected to that compliance which I know I have to comply with. If that was the wrong approach, that is the wrong approach, and we have to take the proverbial beating that we receive for that. But as long as it is on record that my client didn't just simply write a letter or sit back or sat on his hands, but that he engaged a formal procedural process to help him clarify the terms of his compliance in respect of that particular date, then that's as far as I can take it. But I take that, Commissioner Baloy, and may I also say on the record that this is now the third instance that the Commission has raised languaging and stridency in the conduct of the legal team, in the conduct of Mr. Karim's legal team. As Mr. Karim's leading counsel, I will take responsibility for that, and I again apologize to the Commission for those terms, but I hope the Commission will understand that the obligation on us, on as Mr. Karim's legal representatives, in circumstances where he could be the subject of coercive force, is to represent him to the best of our ability with no regard to personal consequence, fear, or favor. And so I take the admonition in the way that it is delivered, and just to assure the Commission that that was never meant as a sign of disrespect or willful non-compliance, but it was in what we see as the legitimate pursuit of our responsibilities to our client as his legal representatives. Thank you, Chair. Thank you, Commissioner Baloyi.
I accept that, Mr. Premit.
Mr. Premit, this is directed to your client and other witnesses that are still to come, and this is very important because officers of this commission don't get to speak for themselves, and allegations are made in the papers that affect the officers of this commission. I just want to place it on record that the rules of this commission require that they take the oath of secrecy to preserve confidentiality of any document that comes to this commission. And Regulation 12 says if they breach some of those regulations, it is an offense. So all of them take that obligation very seriously. And we as commissioners, we administer that oath and we make it clear to them that, these are your obligations. Everything that comes here is to be treated as confidential. I just needed you to know that, and any other witness that comes after your client, they know that, so that allegations should not be made that if officers of this commission come across statements or documents, they won't treat them with confidentiality. I think it's very important that that is made clear because that was the fear as I understood it, and it is put on affidavit. They don't get to speak for themselves. But we know the regulations. As I said, some of these documents are on the website. So can we just understand that so that going forward, you know that that is the position. It is not directed just to your client, but anybody that comes after your client.
Of which I assume there's going to be many. But
I hope they don't repeat what was said this morning.
Commissioner Khumalo, may I say I accept that. And indeed, had the confirmatory statement of what you just put to me, which we received in the directive on the 3rd of March, in paragraph 7, be said on the 18th of February, then that might have changed our position being in front of you. But I've heard what you've said, and I'm sure all the television cameras have flighted that as well. Thank you, Commissioner.
If they repeat it, I'm going to blame you.
Wouldn't be the first time, Commissioner Khumalo.
You wanted to say, or should I quickly raise my issues and then you come thereafter? You want to come in now?
Chair, it is related to the issue of...
I just hope it won't result in an unending ping pong.
No, Chair, I'm sure you will ensure that it doesn't.
Yes.
It really is to say two things. The first is that the effect of bringing the application on the 18th of February was not to suspend the ruling of the 27th of Feb. And so I hear my learned friend saying...
I think that was the first, or after my preliminary point, I think that was one of the very first issues I raised. I think Commissioner Baloyi as well has touched on it. I think the point has been made in that regard.
I won't say anything further on it, except it was important from our perspective as the evidence leaders, because there are allegations that are being made about the evidence leaders in this. And so it doesn't suspend the ruling. It was important from the point of view of the evidence leaders in the way in which they handled that in this. And so it doesn't suspend the ruling. It was important from the point going forward. But the second thing was that my learned friend said that the statement was materially connected to the application. And that was not at all apparent, and until this moment, it's still not apparent to me how it is materially connected to the application. If Mr. Karim had said, my statement will contain information that cannot be disclosed, and that it's part of my application for the in-camera hearing. Part of why I need this is because I'm going to say something that has to be kept confidential. That I understand. But that's not the ground that was advanced in the application. And what is in the statement is not anything that has not already been said in public in the High Court by the witness.
Thank you, Ms. Hassim. A quick response to the second point only, please, Mr. Premhead, if you have it.
All I'll say is that I don't know what more my client can be expected to do in the circumstances where he comes to the commission, places the application and the correspondence where the exact justification sought by my learned friend is placed. And that's not to do what my learned friend has, I think, suggested, which is that it's about the content of the statement. It's about the status of disclosure it's the status of the hearing prior to the disclosure of the statement, not the content of the statement itself. So that's the consistent line we've taken in these proceedings.
Thank you, Mr. Premhead. I have two very brief points to raise. There's the issue of the offer of protection. There's a dispute as to whether the offer was made previously. I will leave that and proceed to what the attitude is now, because Ms. Hassim has said the offer is being extended even as we speak. Is there a response? If not, will a response be given to the evidence leaders as soon as possible in this regard?
Chair, may I say that we have to take an instruction and we'll give a response, but I must just say this.
Yes.
My client is scheduled to come before this commission within 48 hours. My
Yes,
learned friend was talking about things like threats assessments and all these other kinds of investigations that need to happen. So I mean, practically speaking, even if he wants to accept that, I don't know to what extent all of the necessary processes are completed within the 48 hours that he has available. But we'll take an instruction and we'll come back to you on that. Thank you, Chair.
Thank you. Then there's also the issue of the supplementary bundle. This morning I understood you to accept that that's due today and that you will accept it when it's furnished today. But when you were arguing this afternoon, I understood you to be saying it was due at a specific time this morning and that by now it's late already. I just want to understand what exactly you are saying in this regard. What's the point of substance being made in this regard? Are you saying it's late and therefore your client will be prejudiced if your client gets it later than whatever the morning time was?
Yes. And the reason for that is that we were under a time pressure to file by a particular time. That was specified in the directive handed down as 9 o'clock. 2 days later, business days later, 9 o'clock, the statement, the supplementary bundle has not been given. We are now here on the Friday afternoon at 3:15. I'm instructed it's still not being given.
What were the exact terms of for the filing of that?
You'll remember that comes from the original order you
Yes,
gave
but
in the context of
what were the exact terms?
within 48 hours of the receipt of the statement. And so now I'm saying 48 hours has actually lapsed. And I'm not just complaining that 48 hours has lapsed. What that has an impact on is from Friday 9 o'clock until my client has to appear in front of you on Monday at 9 o'clock or whatever the actual time is, the absence of the bundle since this morning is now eating into our...
What time was it this morning?
9.
9.
That we had to deliver the statement yet. We had
No, the bundle, the supplementary
We would
bundle.
have anticipated it 2 days later, meaning 9 o'clock today in the
Today,
morning.
9 today.
Yeah.
And at 9:30 you were here.
Yeah, and it hasn't come.
And would you have used it meaningfully, or is this a technical point?
No, we
Mr.
would have.
Mr.
As you might notice, one of my team is not here today because he's off sick. But he would have been the one to take up. He was off sick and not present because he has a contagious illness, which means he should be isolating. But he would have been in the position to already start looking at that bundle, engaging our client, and so on. And so that's just the reality of where we are placed.
But Mr. Premhead, this point about the exact hour was not made this morning. This morning you seem to accept that this bundle is to be given to us today. And it was already past 9 o'clock, and it did not suggest that you are late because you did not give this to me at 9 o'clock. It seems to me that this is an about 10, and I'm not taking kindly to that at all.
No, I accept what you say to me, Chair, and I'll say that it's not an about turn, because when we were given the short...
It is. If after 9:30, when argument commenced, if after 9:30 you said the supplementary bundle is due today, and you said it in a context that was receptive to the idea of that being given to you later than the start time of the argument, all of a sudden now you are insisting on 9, and you are already past 9 when you made this point. That is why I'm saying this is an about 10. If you want to, we can actually listen exactly to what you said. And I think I'm correct on this.
No, I don't think that's necessary. And I hear what you say to me, Chair, but all I'll say is that even if 9 o'clock wasn't the fixed time, or alternatively, my failure to mention the 9 o'clock issue when I addressed you earlier now causes the effect that it didn't have to be given at 9 o'clock. The point that I would make simply is that it's now Friday afternoon, almost 4 o'clock.
Do you remember as you were arguing, I think I even asked Ms. Hassim, will this supplementary bundle be served today? And you said yes. And Mr. Premier, you never said, but that will be late already. You never said so.
Chair, may I?
Yes. Yes.
Because what is happening here is important. It's again the applicant creating rules and demands.
No, please respond when Mr. Premhead is done. Let's just continue with the debate with Mr. Premhead.
It's on the same point, Chair, but okay.
No, so that you don't, it doesn't become a dialogue between you.
I never know when Mr. Premhead's done or not.
Yeah, no, you're still arguing. I hope you follow what I'm saying, Mr. Premhead. After 9:30, during your argument, you, in a manner that is receptive to the idea, accept that the bundle is going to be served. You do not appear to be opposing that on the basis that it was supposed to have been served at 9 o'clock, and therefore it's late already. You did none of that. If anything, as I've said, I think 2 times already, you were receptive to the idea that the supplementary bundle was going to be served after 9 a.m. in the morning. So it's on that basis that I say I see this as nothing but an about 10. It's on that basis that I say so. And I added that I do not take kindly to it.
Chairperson, I'm instructed that the bundle has now been emailed to us whilst we've been having this engagement. So my prejudice is cured.
Thank you very much. Thank you very much. Those are the only 2 issues I wish to raise. I wished to raise with you, Mr. Premier. I don't want it to get to the ping pong that I said I do not want it to become.
No.
This issue has been resolved now, Ms. Hassim.
Chair, can I just put one point of clarity? There was never any agreement that it would be filed by 9 o'clock this morning.
No, I understand that perfectly, but I understand the point to arise from calculation of 48 hours, not that there was any agreement. But I'm saying what I said despite the mathematical calculation because I just find it very strange. Yeah.
I appreciate that, Chair. My point is not about yours, it was about...
No. Even the
48 hours was never...
I guess I'm addressing
Yes.
Mr. Karim through you. Yes.
It's merely to say that the 48 hours was never an agreement.
No.
The 48 hours comes from your ruling on the 6th of February relating to a different set of documents.
All right. No, thank you.
Thank you, Chair.
Thank you, Council. Thank you all, to all of you. I will make my ruling on this at 9:30 on Monday, and I hope that it will be a written ruling which will cover both the reasons for this morning's ruling and also then the ruling on the aspect that's been argued now, plus the reasons for it. We earlier touched on the possibility of the filing of a supplementary affidavit on the issues that I engaged Mr. Premhid on. I do not even trust my memory to be able to articulate those. I trust your memory more than mine, Mr. Premhid, on that.
To interrupt you whilst you are talking, but my learned friend indicated she also doesn't remember. I remember that this possible supplementary statement is to deal with issues such as who could potentially be the source of those threats.
That was the thrust of it.
Yes,
that was the main.
The circumstances
yes,
and
yes.
the reasonable
yes.
version of the
That
crime.
was the thrust of it.
Yes.
Thank you. I direct that a supplementary affidavit, if any, underline if any, must be filed by midday tomorrow, and a response to it, if any, by 7 p.m. tomorrow. That's the direction, but I may just add that by making the direction, we're not necessarily saying that anything will turn on that. But when you write your reasons, you never know where the pen might lead you. So I want to avoid a situation where we just might say, oh gosh, if we had directed that there be such a supplementary affidavit. So it's on that basis that I'm giving that direction. Let us adjourn and resume at 9:30 on Monday, and we will resume here. Perhaps let's see counsel outside regarding the practicalities and so on. Let's adjourn.